This comma.
Preliminary hearing.
Which matter, matter, the identical matters, interim orders are passed. Today, my lord, all the KB matters your lordship said, other my lord, unfortunately not there. I brought the memo. All KB, these are all, my lord, where lordships had assigned dates. And also, my lord, there is one being spoken to matter also.
He's spoken to me.
Yes. This is not the interim order where the identical matters I am facing threat of disconnection.
When do you want? Monday.
Tomorrow. And other matters, not which date given matters. Not should be checked. Whichever matter. Yes.
Not Is it in the B group or it is in the preliminary hearing? What is it, memo? What is the Was there any interim order granted by this court to give some connection? Is it there? No dates. No, we will see. What can see, memo? What is Which matters there?
Number 1, number 7.
I appeal for the petitioner.
Number 8.
Petitioner.
Just a moment, Mr. Senior Counsel. Just a moment. We are calling out page-wise numbers. Page-wise. Just a moment. Our first matter.
Page number 8, 30 to 33. Page 9, 34 to 36. Page 10, 37 to 40. Page 11, 41 to 46.
Which of the petitioner counsel this is matter after the vacation?
Page 12, 47 to 53.
Respondent counsel seeks time to file objections.
He appealed for the petitioner. The petitioner's father was an employee of the KEB. He died while in service. The petitioner appointed on compassionate grounds.
Yes.
Upon compassionate grounds. Now they are recovering the amount at the rate of 21,123 per month on the ground that they have wrongly paid the amount. That the order of the recovery not be served at all.
On what ground they are seeking for recovery from your salary? What is the ground made out by them for recovering the amount from your salary?
No document has been furnished to me to know how they arrived at the conclusion. In fact, I wanted the copy of the order. They say it's not concerned. I apply under Right Information Act. They say it's not concerned to me. Then how can you recover the amount? Simply covering letter has been issued. Another not be served at all. When yes. I wanted a copy of the order, they refused to supply. On the contrary, they are going recovering the amount.
Yes, yes. Issue emergent notice to the respondent, returnable by so.
And I say for stay of the improved order, recovery of the order and state.
The
21,000 they recovery every month.
Senior learned counsel appearing for the petitioner submits that the respondent. Which respondent is recovering the amount?
Respondent 3.
Respondent number 3.
That respondent number 3. Respondent number 3 is recovering a sum of rupees 21,000. What is the amount?
21,120.
21,220 from the month of March 2024 from the petitioner's salary. How much? And without the petitioner being heard and no opportunity being afforded to the petitioner, the recovery amount to the said extent is being deducted from the salary of the petitioner. The recovery from the petitioner's salary is contrary to the judgment of the apex court. In the case of Shambabu Verma versus Union of India, 1994, Part 2, SCC 521. In the said circumstances, the respondent number 3 is directed not to recover from the salary of the petitioner a sum of rupees 21,120 till the next date of hearing. Yes.
Much obliged.
Seeking a direction to dispose the early proceedings which is initiated.
Okay, how can we give such direction? You know, apex court has been consistently saying that we should not give such direction to the subordinate courts.
Grievances alerts.
No such directions we will not give such. Look at the plight. You are only because you are entitled to come to this court, you want to get a privilege of giving a direction to the trial court to dispose of the matter. There are so many people who are waiting in the line. Correct. You file, you insist the concerned court. Not
The order is passed in the year 1984.
When did you file the application?
The application is filed in the year 2022.
So you file an application in the year 2020.
Three times this court has directed without prior to passing any order, there should be a notice to all the stakeholders.
Correct. You were aware that there was a proceedings pending. When you had approached this court seeking a specific direction, that no notice was issued to you. So you were aware about all this proceedings. We will not give such directions.
We demonstrate with two documents.
Whatever you demonstrate before this court, you go and demonstrate it before the consent court, not before this court. And we will not issue such directions.
We have made 22 submissions. 22 draw your lordship's attention to the orders that are passed earlier. Kindly look into page number 109. This was the order challenging the regrant by the grandparents of the petitioners. Page number 102, annexure B, operative portion at page number 109.
Yes.
109. In all these writ petitions, the point for consideration is whether the impugned orders of regrant are liable to be quashed for the reason that no notices were served on the petitioners before the orders were passed. Then a government advocate fairly conceded after looking into the original records that the petitioners were not served with the notice. They were not heard under sub-rule 4 of rule 3 of the rules framed under the Act, and therefore in the fitness of things, these writ petitions deserve to be allowed. In view of the facts stated by the learned government advocate, I am of the opinion that these writ petitions deserve to be allowed, and hence the following order. The impugned orders in all these writ petitions are quashed, and these writ petitions are allowed. The Tahsildar Bangalore North Taluks, Bangalore is directed to afford a fresh opportunity of hearing to all the concerned parties, including the petitioners in these writ petitions, and dispose of the application for regrant afresh on merits and in accordance with law within 45 days from the date of the order. But subsequently, there is an order passed similarly without notice. The same order is challenged in MA Annexure C. That order was challenged at Annexure D, page 152. I will only read the operative portions.
All were on the ground that you were not served with a notice, correct?
Correct. That's my grievance. That's my grievance. When there is a specific, subsequently also, kindly look into page number 176. This is subsequent writ petition with respect to the very same scheduled property, which is challenged in the present writ petition. Page number 177. I will read only the operative
This
procedure.
order of MA 50.
MA, my lords, MA, subsequent to the order that was passed in the year 1984, the concerned Tahsildar passes the order regranting the scheduled property without notice. And MA came to be dismissed. That MA order came to be challenged before this honorable court. And this honorable court kindly look into page number 177. Last 5 lines from the below. In that, the persons who had been regranted, page number 177. Last, from the below, it's 5 lines.
The petulation does not tally with your submission.
177 minutes.
Which is that order?
Internal page number 27. 27 of annexure.
27 is page number 231. Yes.
Next, this is the order. Because at last, in that the last below, in that the persons who had been regranted the land were required to be heard, and the present petitioners, being the persons who had been regranted the land, not having been heard, results in failure of justice. It is on this short ground that the matters would have to be remanded to the Tahsildar for fresh consideration. Though by effects of time, there are several claimants who claim legitimacy to the transactions under which they have come into possession of the lands. It is also appropriate that they be given a right of hearing as well as to address the validity of their claims vis-a-vis the petitioners who claim as the persons who had been granted the land in the first instance. Hence, without expressing any opinion about the validity or otherwise of the claim of the several prayers, including the present petitioners, the respondent as well as the impleading respondents, the orders in annexures P and R in WP 3790/2009 and the order at annexure A in WP 14133 of 256 of 2009 are passed. The matters are remanded to the Tahsildar Bengaluru South to re-hear the same after issuing notice to all the parties concerned, which would mean
This is
that
all available for you to address before the MA court, correct?
Subsequently,
Is it not?
Subsequently, once again,
You store all your energy to before the MA court.
all that is done, my lord, and the matter is pending consideration for
Correct.
more than 2 years.
You are not going to direct the court, district court, to pass any appropriate orders, giving some timeline. That is not the work of this court. Is it not? It is for the district court to take its call. We don't know how is the board.
I understand where your lordships are saying, but our only concern is
What we propose to do, we will pass order saying that we are not going to grant you any relief in this. What do you propose to do? Yes. What do you propose to do? We are not going to interfere now. We are not going to give any direction. Yes, take that.
because if at all I can make a request to dispose of the matter or the applications or the applications.
This court has already expressed to you. This court is not going to give any direction.
Because it is from the 1984 and
You know what is the law on this point. We will not interfere. We will not give any directions. The petitioner is seeking for the following prayers. The ground made out by the petitioner is that MA 44 of 2022 filed by the petitioner is pending for the district court since 2022, and the direction needs to be accorded to the district court to dispose of the proceedings by framing or by fixing a timeline. The apex court has consistently held that such directions cannot be given to the district court until there are some compelling circumstances. This court is of the considered view that such directions cannot be given to the district judge to dispose of the proceedings, as only because the petitioner has approached the court and he has a privilege of seeking such direction without considering that there are many other litigants who are who are before the district court seeking for disposal of their proceedings. This court is of the considered view that such direction has sought by the petitioner in the present petition is not amenable to this court, and this court passed the following order. The writ petition is dismissed. The CGP to take notice for SCGP to accept notice for respondent number 1 and 2. Where is that order? Which is that writ petition?
You know, see, it's now people were see the main cases.
Dilapidated condition. What is the distance? It doesn't come within any restriction area as per rule. Now he wants to shift, and there's a correspondence made by you stating that he is entitled to shift the premises. Now suddenly you say, no, the petition is not in a dilapidated condition. You can't shift. SCGP to accept notice for respondents 1 and 2. 1 to 3. 1 to 3. Yes. To file objections, if any, by this to file objections, if any, by 1510. Badri Vishal. Yes.
Petitioner melodies was accorded sanction for constructing melodies a switching station. There was a time limit within which melodies the construction was supposed to take place. Now, I had sought melodies in 2020. At page 116 melodies, there was a writ petition filed by the petitioner seeking for extension of that time. Its relevant melodies at page 134 was the interim order passed by this honorable court at page 134.
Yes.
Second parameter.
134.
134. There was an interim order passed by this honorable court where protection was given, my lord, since the proposed 30 megawatt power which is sought to be drawn by the petitioner, for which certain permissions were required to be procured by respondent number 2 and 3. The interim order prayed for by the petitioner to restrain 2 and 3 from disconnecting electricity supply has to be considered favorably for the present. The respondent number 2 and 3 are restrained from disconnecting electricity supply granted to the petitioner as per an extra so and so till the next date of hearing. That, my lords, was extended from time to time. Now, the previous time, my lords, we had approached this honorable court because although they found, my lords, rocks in the construction site, and for blasting, my lords, there was blasting permission which was required. So, because they had not given the blasting permission, my lords, we had approached the court saying they have not yet to accord permission. So, therefore, we had approached this honorable court for extension of time. Now, at page, my lords, during the pendency of that writ petition, at page, my lords, 144, if your lordship sees, during the pendency itself, on 15/11/2023, sorry, my lords, at 8th February 2024, at page 144, they extended the time, my lords, by making a reference to all the earlier orders and communications. At page 149, my lord, if your lordship sees, bottom of page 149, item 1 anta ide. There, my lord, so and so shall complete the 220 kV switching station and associated line works by September 2024 and also shall furnish revised undertaking to PPCL
stating that the switching station work will be completed within September 2024. This was, my lords, and to give further bank guarantees, etc. Now we have complied with everything. 95%, my lords, of the work is now complete. Now your lordship will see the writ petition which was filed also came to be disposed of at page 151. Recording. Yes. At page 153, my lord, at paragraph 4. The counsel for the petitioner has placed on record the communication dated 8/2/2024, which I read to your lordship now, by which the time for completion of the switching station has been extended up to September 2024. Therefore, the representation submitted by the petitioner having been considered positively, the relief sought for in the petition does not survive. We got the extension, my lords, in the next 5 days. Now, what has happened? There is a, my lords, a report which has been filed. A status report at page 159, if your lordship sees, where the fifth respondent addresses to the second respondent, my lords, the status of the work of construction.
Yes. Yes.
If your lordship sees page 160, after recording whatever work has been completed so far, however, due to inadequate space to install a battery set, a revised layout plan for battery room has been sent for approval, which is yet to be approved. Hence, it is opined that as a last chance, time extension requested by so-and-so may be given up to 31/1/2025.
The time is extended till 31/5.
That is of the opinion of the fifth respondent who writes, my lords, to the second respondent. Now, this, based on this, my lords, we address communications to the second respondent also, saying, please extend the time. Your own officers have said so. Now, that has not been considered. Now, there's an imminent threat, my lords, that on 30th September, two things will happen. They are going to disconnect the electricity supply, one, and the bank guarantee that I have given, my lords, which has been extended from time to time, they may encash the bank guarantee. So therefore, my prayer before your lordships now is to consider my representation at Annexure A, where I have recorded all these things. And I have said that you are the one who is supposed to give me the battery room drawings, approval. Then I can construct the battery room, which will complete the project in total. Now, from the date of such approval, my lords, I need about 4 to 5 months to complete it. At page 32 is please.
Now, how is the prayer seeking for that encashment of bank guarantee?
Please.
How can we say that?
My lords, I had
So far as your prayer to consider and prayer to state that you were given extension of time from
Please.
till 31/1/2025 is fair enough.
please.
But your apprehension that they are going to disconnect the connection in light of not completing the construction, that also we can understand.
Please.
Now, there is a question of regarding the bank guarantee.
The reason, my lords, is now they have written. I am informed that they have written saying encash the bank guarantee. That is not communicated to me. As much as the fifth respondent has addressed to the second respondent, my lord, saying that I am of the opinion that it should be extended till January 2025. The issue that arises, my lords, is my bank guarantee, my date of completion as per the previous order also is till 30th September 2025.
30th September 2020.
That is the order also passed by this honorable court, which I read, my lords, at page 151. At relevant at page 153.
That was up to September 2023. That is September 30th.
September 30th is the date. Now, September 30th, if they don't consider my representation for the purpose of extending it, there are two consequences which is going to happen. One, my lords, is that the electricity supply which is being given to me to connect my electricity to the steel plant that I have, that is going to get disconnected. That is one. And that was primarily given, my lords, only to secure till the switching station is constructed. Second, my lords, was that the bank guarantee that I had given, my lords, will be encashed. That's a natural consequence of what is going to happen. Therefore, my lords, these two interim prayers I have asked for. When they themselves say, my lords, that till 2025 you give it, which is not being considered by the appropriate authority, that is the second response.
Who appears for
Your
the,
lordship, sorry.
who appears for the contesting respondent?
KPTCL, my lords, just now was appealing.
Who's the counsel appearing for the, any standing counsel?
Sumana Naganand. Even in the previous order, she appeared, my lords, at page 153, if your lordship sees.
Pursuant to the order passed by this court,
Yes.
which was extended up to September 2024, what
Yes.
happened?
Thereafter, my lord, if your lordship sees,
Submitted a
I have
representation.
submitted 3 representations, my lord. I have submitted representation on 29/6/2024. I have submitted on 27/7/2024, 12/8/2024, 27/8/2024, and pursuant to all of that representation, my lords, the 5th respondent addresses a status report at page 159 in the month of September 1st week on 9/9/2024.
There should be some apprehension on your part
Please.
that in spite of this status report being submitted
Please.
by the corporation to the
Please.
superintendent of engineer, who is the deputy senior, that the time has to be given up to 31st January 2025. What is the apprehension now for you?
Apprehension is 5 days, my lord. We are already on 25th. There is no extension.
SCGP to accept notice for respondent. Is SCGP to accept notice for respondent number
1.
1. Sumana Naganan, then a counsel to accept notice for respondents 2 to
6.
6. Then a counsel for the petitioner settles that the petitioner was sanctioned with 27. What is that?
Megawatts.
27 megawatts. Power for tapping the existing 220 na?
220 kV.
kV voltage level. Itigi Lingapur line with a condition to construct the 220 kV voltage level switching station and hand over the same to the KPTCL within the time stipulated, and the said time was extended from time to time, and the extended time was up to September 2024. Then the counsel for the petitioner brings to the notice of the court the letter addressed by the Office of Karnataka Power Transmission Corporation, stating that the time for extension will be given up to 31st January 2025 in light of the prevailing circumstances. The apprehension of the petitioner is that as the representation of the petitioner seeking extension of time is not yet considered, which expires in the month end of September 2024, there would be disconnection of the power supply, and added to it is the agony of encashment of the bank guarantee submitted by the petitioner. In the said circumstances, this court directs the respondent not to disconnect the power supply granted to the petitioner and to encash the bank guarantee. Respondents 2 to 4 till the next date of work.
Up to it, yeah.
Not to encash, not to encash. Not to encash the bank guarantee.
This is pertaining to the shop, ATM shop, recently they have again issued us a letter requesting to produce the documents.
What is the document to show that you were allotted the burnt shop? Yeah, simple. What was the document to show? You said that certain shop is burnt, right?
Yes.
To show that the burnt shop was allotted to you, what is the material?
I did not have the license, but however, page 30 of the writ petition, typed copy of election, 29 and 30. It is license number 468.
30.
Yes, my lordship. 30 is the typed copy. My lordship may also see 29.
30.
Where license number 468, 1988, license as A. This is the only document to show that initially it was not 50, my lordship. Later it was given shed number 70.
What is that? There should be some document which says that, no, you are not given 50, but you have to be given 70. Is it not?
My lordship, that was 50 was a temporary allotment.
No.
Thereafter,
And
70 was given.
And what is this? This is a license which has been given to you?
Yes, your lordship. However, we do not have the original license agreement also. It got burnt in the shop. That's the only documents we do not have.
This
Moreover,
is
my
a Xerox,
lordship.
sir. This is a Xerox. This is a copy of it.
Copy, yes, your lordship. Moreover, my lordship, may kindly look into page 89 of the petition. Opinion given by their own counsel.
89, huh?
Yes, my lordship. Para 4, may I read?
Yes.
I have carefully perused the records sent to me. It is noticed that there is no dispute that an allotment was made to N. Manjunath, and he was allotted temporary shed number 70 on leave and license basis. Even though the initial allotment was made for a period of 11 months, the allotment continued even after the period of 11 months, and N. Manjunath was in possession of the shed till the date it was burnt down. The market committee had not taken any decision to cancel the allotment of N. Manjunath before it was burned down. Further, from the photograph, it is clear that his shed and adjoining shed was burned down due to the fire. That being the case, N. Manjunath is entitled for allotment of alternate place.
How did you get this legal opinion?
RTI, my lordship. We have not received any of their communications. We applied to RTI and we received all this. And also, my lordship, initially they had passed a resolution. Their committee meeting, page number 80. My lordships.
Page number?
80 onwards. Proceedings of the meeting. May I read, my lordship? To Shri N. Manjunath in Yashwantpur Main Market Yard shed number 70 was temporarily allotted, and the said shed is caught in fire and burnt on 22/2/2000. And for the allotment of the alternate shed have requested on various dates is examined. The advocate of the committee from Shri T. Swaroop on 17/1/2021, legal opinion is obtained as the said person is carrying out the online business trading and have informed that he can be allotted temporarily the shed in Dasanpura submarket. Once again, Shri N. Manjunath on 18/1/21 submitted an affidavit to the committee, and in the said affidavit for the allotment of the shed in Yashwantpur Main Market Yard and accepting the onion and potato, he will also carry out the rice and other food produce trading. And in this connection, once again from the advocate of the committee, the legal advice is obtained, and the advocate on 9/2/2021, if onion and potato trading is done to Dasanpura submarket yard or accepting the potato and onion if carries out rice and crop trading business, the said person in the presence of the notary stating that he will carry out the trading of rice and dal to his affidavit is obtained and submitted to him in Yashwantpur Main Market Yard. The allotment of alternate shed can be done. In this manner, the advocate has given his opinion. Further, the said person, shed number 70, is burnt in fire on 22/2000. and the market yard in connection with the allotment of alternate share have sworn as true and submitted the affidavit in documents. And in case if it is found wrong, to take legal action and to cancel the alternate share has accepted. And in this manner sworn before the notary affidavit submitted is verified. Further earlier, shed number 69 was caught fire, and to the said firm BST Enterprises in Coconut Yard, shed number 19/31 is alternatively allotted, and similarly to Shri N. Manjunath in Market Yard, Coconut Complex Shop, alternative to allot number 28/31 to obtain the approval of the competent authority was accepted and decided.
What is this letter of 1/6/2021? What is the letter of 1/6/2021? Some director has made some recommendations.
Yes, sir.
What is that 1/6/2020?
Page number 76, a translated copy. The APMC have given a letter to the director stating Shri N. Manjunath
70?
76 of the writ petition. Translated copy, my lord. Shri N. Manjunath, number 21, PD Lane, Cottonput Cross, Bengaluru, under reference 3 in his letter has said that earlier in the year 96, in place of the shed number 50, shed number 7 allotment order or the committee having taken decision copies is not available, hence has requested to verify in the committee files and send the same. Under your letter, reference number 1, instead of shed number 50, the order of allotment of shed number 70 or the committee taken decision copy and earlier shed number 79 is got burned in fire. And to the said firm, GPS Enterprise on the basis of the leave and license, alternatively the shed being allotted, order copy and the committee having taken the decision and from the competent authority having obtained sanction, order copies asked to be submitted. But N. Manjunath failed allotted order copy and the committee taken decision copies are not available. And to BK's Enterprise on the basis of the leave and license, shed number 19/31, allotted order copies enclosed with this letter.
This translated copy is a true translation of Kannada. So it doesn't have any meaning to what it has been said.
The lordship in this.
What does it say? You kindly tell the story. What does it say? What does the letter say?
The lordship, there were two shops that got burned in that this one. In that one shop, they had the documents plus they approached the honorable court based on that direction. They were given a alternative shop. We did not have any documents. We have already given our representation, but they have not considered this. Hence, having no other option, we have approached this honorable court for direction.
What was that letter? What was the translation of that? Okay. See, you must be having some allotment letter. See, he was running even the premises, he was running. Correct. Then alternately, you give a license for this number. Then, see, when what is not available, why do you ask from them to give that copy when they are already in that? They're having a license to that survey number, that shop number. So when was it? When was the license issued? Oh, yes. When was it? When was it burnt? Oh. See, when did you recommend this? When did you recommend? On 24/2/2021. When a resolution was passed, you said this is the opinion that they are running the shop, and this is the opinion, and the shop has been burned. And in alternative, they have to be given an alternative shop. Then now, correct. After that, you come back from your resolution. No, when Recommendation is on basis of some documents. Is it not on basis of some documents, or just you pass some resolution? Without looking into documents, do you pass resolution? Just tell the court. Correct. Maybe director, we don't know what director is doing, but when you pass a resolution, when you pass a recommendation, will you not look into the documents? And can you go back from the recommendations? Can you go back from the recommendations? Can you go back? No, what is that? Every time you have to take instruction. See, now in this, you give an opinion. The legal counsel gives an opinion saying that this is the thing. They are running the shop. They have the shop is burnt. They have to be given an alternative shop. Then a recommendation is made on your legal opinion, and a recommendation is passed on verifying the documents that they are running a shop number 70. And now you come and say before this court saying that no, don't know when the license was continued or not. We are not aware. Ask them to produce the allotment letter. What is this, Mr. Khan? We don't know. We'll direct the director to pass orders and give the shop to them in light of the resolution being passed. No, director wants many things to happen. We don't know what all he wants. Correct. Now, where will they produce when they don't have? The shop is burned. The shop, all the documents are in the shop. This is one type of harassment, Mr. Consul. Hmm.
So this is the argument entered between them and the APMC. Not that number 70.
Yes. And you say that you have not signed that? Ah. Correct. Ah. Do you not see? Do you not see that? Wonderful. If you don't have the records itself, we can't do anything. You pass. You give them the shop. Krishna is seeking for a writ of mandamus, bad direction to allot the shop to the petitioner by the respondent. Correct. That is not stated so in your recommendation. Did you say that in your recommendation? You said please allot them. You allot them some shop which is not permanent. Correct. Yes, you give on terms of 69 itself, what you have given to 69. Correct. Where is the document of 69? Then on what ground did you give it? Correct. Where is that document? Correct. Where is the document to show that they were not given on permanent allotment? Where is the resolution regarding 69? When you're talking about 69, you have to show the documents pertaining to 69. What does the rule say?
There are two types of allotments under the rules. Even license certificate and lease book. Even license is only on the rental list. So maximum of 55 months, renewable every 11 months. Even here, agreement is for transfer of property. But even license certificate is entered for 10 years. Here are the conditions where it is executed in favor of the allotment.
Now, as per the agreement which you entered, at page number annexure C. Hmm.
So,
Where is that shop number 50? Then you should have made, why is such an effort's been made by you not to give him a one shop? When he was admittedly running one shop number 50, afterwards he shifted to 70. When you say that permanently you cannot give, why can't you give it for 1 year then? Hmm. By tomorrow, if you don't give an license to the petitioner, whatever basis you are saying, we will allow, directing you to allot this site to her as per the recommendation. Allah, do you understand what the court said? Yes. So do it by tomorrow, otherwise we will allot the said shop to them. List is tomorrow at request of respondent. Otherwise, we'll pass an order saying that in the event you don't comply the order of this court, we will allot this whatever they are seeking for in the prayer. Correct. Then allot them leave and license. Why are you not allotting leave and license to them? Yes. Tomorrow. The preliminary hearing list. Post this matter before the concerned roster bench.
Because if you for a random,
We cannot give such data. It has to come from by following the procedure.
any date.
It has already been classified as KEB. We registered to classify properly. Yes. And listed before the appropriate bench. Our classify ಮಾಡಿದ್ಮೇಲೆ ನೀವು move ಮಾಡಿ. To delete the name of Putige R. Ramesh as counsel for respondent number 3. As Putige R. Ramesh is a senior counsel, designated senior counsel. And show the name of Parasakar. A.S. Parasarar Kumar for respondent number 3. List this matter at request of the respondents after Dasra vacation 2024. Now, what is your right locus standi? They are not interfering with your route, right? I think it's already ready. The difference is Pavitra. What is this? Prithviraj. Prithviraj. ಗಂಡ ಹೆಂಡತಿ ಫೋಟೋ ಹಾಕ್ತಾರೆ. She is not the wife of so and so. Original license in there. And then they have produced the photograph of as husband and wife. Who is he? This is the license, original license. Madam, verify this. Verify this. You have produced photographs along with the licensee, who is not your husband. Yes. ಕೊಡಿ ನೋಡಿ ಅದರಲ್ಲಿ goes against you. Objections. SCGP seeks time to file objections as final charge. 2 weeks time is granted. This does matter in the preliminary hearing after Dasra vacation 2024. ಬಳ್ಳಾಲ್ ಅವ್ರೆ ಯಾರು ಹೋಗಿದ್ರು ಕಾರಲ್ಲಿ?
The driver. I'm permitted under the trade.
Correct. That is permitted. If they say it's an owner anta
That is actually that is it. If you base that, my lord, the lordship may come to see my reply at page number 25. I have produced my ID card of the employee also.
No, at the time when he was caught,
Yes.
at that relevant time, he
Yes.
did not deny that he is not the owner. Why did he not say that he is not
No,
the
he
owner?
said that he says that my lord is an employee, but the authority takes him to be the owner of the vehicle. And kindly see page number 25, my lord, last line. Enclosed here with the copy of the trade certificate, insurance certificate, and company ID card.
This vehicle was flying from
Bangalore showroom to
Bangalore.
Bangalore showroom for delivery to a prospective buyer.
Where is the details of that prospective buyer?
I can produce them. I can produce them.
You
Yes,
produce
definitely, my lord, because of this seizure of this vehicle, my lord, I had to get one more vehicle and deliver it to him within the time promise. I will produce.
Let them take notice anyway. You produce the copy
I
of
will do that, my lord. In the meantime, my lord, the vehicle may be released, my lord, but the reason is this, my lord, otherwise it will go waste.
Now that you have already given it to some other
Yes,
person,
my lord, but this vehicle also I can sell it to someone.
you will not give them much time. Let them file their objection. Who appears for Caesar ಗೆ ಎಲ್ಲ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಲ್ವಾ? And if
Under this order, impugned order, my lord, he has seized the vehicle.
Correct. Now that
Yes, my lord,
Caesar
yes,
is before the
that is-
magistrate, is
No, but
before the
it is-
magistrate.
Not that registration itself will not be.
We cannot release the vehicle in this writ petition proceeding when a charge sheet has already been filed by the.
So that information is not given to us, my lord. They have not served a copy of
Give
that.
them a copy. Once the charge sheet is framed, filed, you go and approach the concerned magistrate seeking for release of this vehicle.
Not be empowered to release the vehicle for the reason that, my lord, the seizure was under this impugned order. And I have already come before my lord, I have filed the writ petition. They have not served a copy of this charge sheet.
Charge sheet ಕೊಡಿ ಅವರಿಗೆ. Charge
Yes,
sheet
they have not done that, my lord. That is why I am insisting, my lord, that the vehicle may be released in my favor. Under the condition, my lord, at least.
Produce the copy to show that there was a vehicle delivery to the concerned owner and the person who was traveling was your employee.
That I have already stated, my lord. Kindly see.
You have stated so, but then this court wants to know what was the reason for this vehicle to fly to Bangalore from Bangalore. You said that there was a delivery question
Yes.
to the owner. That is that document.
That I will, my lord, could it be taken up next Monday itself, my lord, so that I will produce those
Yes, at
documents.
request list this matter on Monday. One ನಿಮಿಷ SCGP notice ಮಾಡೋಣ. That has to give the respondent SCGP to accept notice to the respondents. List this matter on Monday. Yes.
I think you are giving this to them. From supply of electricity.
Yes, madam. Yes, you provide them the electricity supply. Yes.
They have to narrate the facts.
This petitioner, you are not pressing for prayer number B.
For we not
Police protection, how is it?
file an application for the concerned
Appropriate report. The petitioner is seeking for the following prayers. During the course of argument, learned counsel for the petitioner does not press prayer number B and submits that necessary application with a liberty would be granted to the petitioner to approach the appropriate court seeking necessary prayers. Next one. The petitioner asserts petitioners 1 to 4 jointly purchased site number 2 formed in converted site number survey number 21 of Patangere village, Tengeri Hubli, Bangalore South Taluka under registered CB dated 27/8/2014. Pursuant to the purchase, the name of the petitioners was entered in the khata and the petitioners 1 to 4 have paid tax to BBMP. The petitioners 1 to 4 intending to develop the said site applied for construction of building plan to the BBMP. Building plan was sanctioned and for the purpose of construction, the petitioners applied for temporary electricity connection, which was sanctioned by the authorities. It is submitted. It is asserted by the petitioners 1 to 4 that they entered into a joint development agreement with one Somia under registered joint development agreement dated 15/9/2016 for the purpose of constructing the building. Pursuant to the agreement, the developer Somia entered into a memorandum of understanding with one D.S. Mohan, proprietor of Saptagiri Construction. And pursuant thereto, the construction of the building has been completed, consisting of 10 flats in total, as per the joint development agreement. And out of the 10 flats, 6 flats bearing number 101, 102, 301, 302, 401, 402 fell to the share of developer Somia, and remaining 4 flats bearing number 001, 002, 201 and 202 fell to the share of the owners, that is petitioners 1 to 4. The petitioners submit that a dispute arose between the developer Somia and the aforementioned D.S. Mohan, proprietor of Saptagiri Construction, resulting in filing of a suit by Saptagiri Construction in OS number 190 of 2023 for relief of permanent injunction to restrain the defendants from alienating the suit scheduled property. The suit scheduled property A, inverted comma, is the entire site number 2 that was purchased by petitioner number 1 to 4 herein. And schedule B properties were the flats which had fallen to the share of the developer Somia. And the petitioners 1 to 4 were arrayed as defendants 2 to 5 in the said suit. And defendant number 1 was arrayed, and Somia was arrayed as defendant number 1. The consent court, wide order dated 31/1/2023, granted an ex parte order of temporary injunction, restraining the defendants therein from alienating the suit scheduled property. The petitioners 1 to 4 after entering an appearance in the said suit, filed an application seeking for vacating of the interim order on the count that the list is between defendant number 1 and the plaintiff, defendant number 1 bracket nalli, Somya, and the plaintiff bracket nalli, Saptagiri Constructions. And so far they are concerned, they cannot be subjected to any hardship because the list is between the plaintiff and defendant number 1. The consent court provided order dated 14/6/2024 modified the interim order dated 14/6/2024. It is the contention of the petitioners 1 to 4 that thereafter they have sold the 3 flats that had fallen to their share bearing number 001, 201 and 202 in favor of petitioners 5 and 6. In favor of 5 and 6. This being the state of affairs, on purchasing the said flat, the purchasers have occupied the said flats and they are living. There is no electricity supply to the premises, to the flats. The petitioner number 1 applied for temporary electricity connection. And on behalf of the purchasers, to the responding authorities to provide electricity supply. And also brought to the notice of the PESCOM authorities that about the modification of the order passed by the trial court. Now they have denied you what they have, they're objecting.
They are not denying. Instead of accepting the court order and providing us electricity supply, they go and address a letter in fact para 14 minutes to Saptagiri Construction proprietor Mohan, and he files an objection. And after that, they are delayed.
The connection is temporary connection, or what is your connection?
No, regular connection. Because I have stated so, because petitioner number 1 had earlier applied for temporary connection, applied for the regular.
The views of the petitioner is that, in spite of the request of the petitioner to supply permanent electricity to the petition premises, on the behest of the proprietor of Saptagiri Constructions, the PESCOM authorities are not providing the essential necessity to the petitioner, such as electricity. The learned counsel for the respondent submits that if all the requisites which are necessary for the supply, for the sanction of electricity supply, it is complied, the respondent would provide the electricity connection. It is not in dispute that the petitioners are in possession of the petition property. Mere pendency of a civil suit would not be a ground to disentitle the petitioner from obtaining any electricity connection in their name, when particularly the interim order is not against the petitioners. Neither there is any direction to the PESCOM authorities not to provide electricity connection. In that view of the matter, this court is of the considered view that non-providing of the electricity connection on the basis of the sanction plan and on not providing of electricity connection or the on the ground that pending of civil suit is not is unsustainable. In the said circumstance, this court directs the respondent to grant electricity supply to the flats bearing number 001, 002, 201 and 202, subject to the petitioners complying with the requisite codal and financial formalities for grant of electricity connections. Electricity connections forthwith. Yes.
Okay, like in any other petition, it cannot take the whole suite.
Yes.
We are living by using generator.
So this R12 is a necessary party. Why was it adjourned? R12 is a necessary party. Just to say so.
Sure, the first matter is the subsequent purchaser. Main matter is the connected matter, which is okay. This morning's the petitioners therein, or one of the viewed by the or of the regarding petitioner in the first matter is only a purchaser from the petitioners in the second matter.
During the non-alienation period,
Under the KVOA, it is regranted in our.
correct. There is a clause in that regrant also that you should not alienate.
If that they are possession and they are universal, they are subject to the husband. It's taken out as well.
No, this, they have to hear this petition, right?
Things are completed ready for.
But the first matter, both are connected, right? Or can we say ಯಾವ್ದಾರ ಒಬ್ರು ಸತ್ತಿದ್ದಾರೆ? You have to say who are the persons who are alive.
Both the parties are petitioners and as well as the respondent, no party.
ಯಾರ್ ಸತ್ತಿದ್ದಾರೆ ಸಮ್ ಆಫ್ ಅಂದ್ರೆ ಯಾರಂತ ತಿಳ್ಕೊಬೇಕು. How can you make such a vague submission ಅಲ್ವಾ? ಇವ್ರರ ಸತ್ತಿರ್ಬೇಕು ಅವ್ರರ ಸತ್ತಿರ್ಬೇಕು ಅಂತ ಹೆಂಗ್ ತಗೊಳಿಕ್ ಬರುತ್ತೆ? First you have to inform who is dead. See, he was pressing for the matter, I believe, right? You were pressing for this matter. Now, if they say it is some respondents or some petitioners have died.
As the first matter is concerned, my submission is respondent number 12 is dead. He was unmarried and.
ಹೌದಾ? ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. We will say you verify. We will say that we will record your submission that is dead. ಅವ್ರು ಸತ್ತಿದಾರ ಅಂತಾರಲ್ಲ ಯಾರಿಗೆ dead? You verify and verify. He was not made as a party. This respondent number 12 died before the regrant. When did he die? You have got the date?
The Tahsildar was the party. That order is of the year 2000. Subsequently, he is died. That's why one of the connected matter not even ahead as
So this petition was of the year 2014, right?
the district court, the MA was filed in the year 2007.
And there he was not made as a party. Not a party. So we'll record your submission that, shall we record the statement of yours that respondent number 12 is dead and is not survived by any legal heirs? Learned counsel appearing for respondent number 2 to 6 on instruction submits that respondent number 12 has died unmarried. At this stage, learned counsel for the petitioner seeks time to get necessary instructions. If you get any date of death and all, I request list this matter after Dasara vacation 2024 in the week commencing from for what? The earlier order. Yes, Mari. We will not give a date, we'll say week commencing from 21st. Week commencing from 14th. Yes. Yes, Mr. Tata. What happened? Correct.
Yes, one application.
So he's got the privilege of filing application. It is like Tariq pe Tariq. So you keep on filing up.
What happens
You
is,
let him file. He's got that. And what is this applications now?
transport department.
After every adjournment, Datar gets ideas of filing up.
No, in fact, my lord, I will submit. The government advocate said that in the order which I have challenged, or the scheme that was issued by the transport department, they put their necessary party. I made the responsible one only as the tourism department. Therefore, I am making R9 as a party. So that may kindly be allowed. Earlier, I had made the 6, 7, and 8, my lord. Who are the central
Now
government.
see, who was central government? We made them as a party.
Central government and the airport authority of India.
Correct. Now I3 is filed for whom?
I3 was for 6, 7, 8.
So they are also filed. 6 to 8 is also represented. ASG.
Yes, sir. Kumar and other. The notice was issued on.
And now?
Now they are represented by Kumar.
And now which is the fourth application?
Now it is for R8, R9 transport department.
Who is the transport department?
State government.
Why do you want the state government to come in this picture? Because it's between you and.
You notice it, right? Sunday, objection that because this annexure which are challenged, the scheme is issued by the transport department.
Yes, what you say, is it a necessary statement?
No, it is the state government which has raised this objection because kindly see at page 84, it is Radhakrishna, Under Secretary of the Government, Home and Transport Department in Diwan. Page 84.
God knows, law needs to be made a party. Which department is only for sake of convenience. State is already a party. It's only a delaying tactic. If the interim order is vacated,
They have been made as a party of respondent number.
well, it's state of Karnataka.
Then it is represented.
Represented by the tourism department.
In our transport and home and transport department.
Already made, madam.
Yes, you have made it. Your correction is there in this.
Then the I told
If you have already made them as a party.
no, not so much. But I said not this.
Huh? Yes, it has been carried out as saying home and transport department. Who has raised? Is it so?
Well, the party because he only said the petition will consider better than this. And on the same day I said, well, an application will be provided. First, well, after 2 weeks.
That is okay.
Now you, in light of them, impleading as
That
one. So you don't press I number 4.
Yes, in view of already the amendment carried out.
And the counsel for the petitioner does not intend to press I number 4 of 2024 in light of the state being already as a party as respondent number 1. And accordingly, I number 4 of 2024 is dismissed as not pressed. Now what next?
Next thing, I number 5, I have filed, wherein respondent number 2 now, they want to stop my taxi operation as there is no agreement which is not continuing after 39/2024. So that agreement is between respondent number 2 and respondent number 4. My agreement or my right comes under annexure E, your lordship kindly see. It is these are the taxi drivers and owners who are operating the taxis from the old Bangalore airport. They have been rehabilitated by the government under the KSTDC. And this is the report of the subcommittee which was constituted then. And they have examined and they have considered the request of our union, inter-union. The lordship could get it at page 41. The Bangalore, may I read, my lord? The Bangalore International Airport development started its operation in May 2008. Consequently, civilian operations at the old HAL airport were closed. There were 3 types of taxi services so and so. While booking space so and so, then, my lord, lordship will come to para 4. 3 says that in the meantime, the unions associations of taxi operators at the HAL airport represented by the government at various forums over a period of time to allow them to operate prepaid taxis at VIA. However, the demand was not considered and suggestion has been made to them to operate city taxis under the banner of KSTDC if they are willing. Now it appears that the original review is split and a new driver union, the Bangalore.
What was the interim order granted by this?
No, one minute, madam. I'll complete it, madam. Let
us understand first.
Yes.
What was the prayer you have sought in this petition?
Yes, prayer may kindly be seen, madam, because that is arising out of the annexed review, madam. So my interim prayer was to allow him to operate, and it was relating to the 6-year bar. The 6-year bar, my lord, which they had imposed under the city taxi scheme. And on the basis of the judgment of this honorable court, which I have challenged before the honorable division bench.
Correct. Now there is already an order not to take
not to precipitate.
So it includes everything, right?
It should include, but in spite of that, what is happening, I tell you. So now here your lordship will kindly see para number 4
of the
page 42, annexure E. So this union affiliated to Inter, and Inter has represented to the additional chief secretary, allowing them to fly taxis from VIL airport. Accordingly, as agreed upon by the Inter to operate its city taxis under the KSTDC banner, this subcommittee is formed to sort out the issue holding the meeting. Now, kindly come to the next page, or of course, the KSTDC, and they have to sort out the commercial rates, etc. They are mentioning they have granted 200 licenses to operate the city taxi, airport, which is called as airport taxi. So the VIL has agreed to take security deposit in installment, but the KSTDC is not ready to accept this. However, the government may direct KSTDC to consider the payment of security deposit in installments. So we have all, if every taxi driver or operator will have to give security deposit. Then the union drivers or owners should enroll with KSTDC and operate strictly in accordance with the city taxi scheme. Therefore, this kindly see union drivers and owners. Accordingly, the vehicle should not be more than 1 year old at the time of the agreement, and the existing state permit should be converted to city taxi permit. This is what the condition was there. Then any other matter, commercial, economic interest should be resolved by KSTDC and union members, usually in par with the other taxi driver owner attached to KSTDC. The union members will submit sworn affidavits to the effect that they were actually operating the old airport and prepaid taxis. Copy of this will be sent to Swarna. Then there is one big petition filed by another driver union. Then it says, however, if the inter demand has to be considered, 200 licenses PSTDC may be considered in order to accommodate 200 union members of the affiliated to Inter, and remaining 75 drivers will be rehabilitated through PSTDC HCC transfer. So 200 licenses have to be given to my union members, Lord. They have to file an affidavit. Now that affidavit, what they have done is, they give me their agreement now. They say that agreement is binding on me. Now the agreement has been renewed from time to time on 30th of September every year or 3 years. Now that agreement is coming to an end. It is in this context. Now the KSTDC has issued, of course, we served the copy of the interim order on the PIL as well as KSTDC that I have produced along with my application. Lot of people get my, and it's this I5. I5.
Yes.
Now this copy is served, not in that again your lordship will see that not to precipitate is what it has been mentioned. Then annexure X your lordship will kindly see. Here they issue the Suchana Patra to the drivers.
What is the Suchna Patra now?
This is Suchana Patra on dated 29/8 and 4/9/24. The lordship to date it annexure X. This is Vahana Malipuru Chalikar Nigam ಹೊಂದಿದೆ ಮಾಡಿಕೊಂಡು ಕರಾರು ಒಪ್ಪಂದ ಮುಕ್ತಾಯಗೊಳಿಸುವ ಕುರಿತು. Now how can it come to an end?
They are placing reliance on this agreement which they say.
Yeah, which they say that is an agreement between PSTDC and VIL, my lord. And my agreement has no connection because I have to give an affidavit to them that I will be operating under the banner of PSTDC and I am
How
operating.
can you issue such a letter to them? How can you?
Notice PIAL KSDC with the agreement 30th September. Renewal application.
See, now there is an
Point.
Earlier you have not done it.
whether they have merits or demerits. Now there is an order passed by this court.
They should be allowed to play. They are being allowed to play. Agreement
We
between.
say that is not the notice. What does the notice say?
Below that there is a Sutwal, your lordship, the NDC.
You can also kindly see.
They say, well, two things. One, I have to allow them to continue. It's not their case. They are being allowed to continue. But the contract, is not only 200 licenses, more than 600 licenses. So far as 600 licenses are concerned, the agreement will come to an end. Agreement forms the very basis. This is the matter. Your lordship, this matter. It is like this. I am not committing contempt, my lord. They are being allowed to play. Till the interim order is vacated, till the interim order is vacated, our expedition is for the will continue.
And why such not to precipitate means any action you should not take.
Well, this is not against them. The problem is the agreement is between VIAL and KSTDC. There are 600 licenses.
Well, I am not concerned with 600. I am concerned with 200
You
union
should
members.
not disturb their flying of vehicles
No,
in light of this.
No, my lord,
Then if that is not, we'll take your submission on record and dispose of that direction that you are not disturbing their flying of vehicles.
my lord, one point.
The merits apart.
Merits apart. Submitting therefore, my lord. Your lordship has heard this.
Well, heard andre, at that point of time we have heard this petition. On merits you may have got a good case, but now at present you would not disturb their flying of vehicles.
No, my lord, it's not being done. We will not do that. But
Then we will take it sub.
For KSTDC respondent. Kindly peruse, annexure W, which is annexed along with the IA number 5. First para.
Yes.
Is it to bring to your kind notice that the expedition of funds from? has passed into model debt case please in bail, not to precipitate the matter, thereby directing the respondents to maintain the status quo as is existing, hence in terms of 2013.
Can actually email.
W, sir, ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ sir. Wait money. Which is binding on all the parties, therein are required to follow till the state WP is finally decided. My lord, answer is the first statement before this article. Order sheet may please be looked into. Order sheet. It is the first order was taken on 25/4/2024. Input notice till the next date of hearing, 25/4. It is continued on 28/5/2024. Next, 28/24 till next date of hearing, 21/4/24, 28/8/24, 11/9/24. Now, where is the order till the disposal of WP? Is it not a misguidance or misleading? That too first statement before this report.
See, Mr. Counsel.
But it is my duty to assist the.
Correct.
I am at the hands of my lordship.
Please.
And when I am in the hands of my lordship, when they are seeking every week they are filing with an application like this. Along that supported affidavit, which also says in the affidavit also supported by the annexer V to X1 are photocopies.
We are not
In
hearing,
between the
Allah, we are not hearing this petition on merit.
No, I want to.
No, we have made it.
Allah. Parties. Doubling heights case is there Supreme Court. Whenever there is a wrong submission, irregular submission, frivolous submission, the petition has to be.
Is the submission made to the court?
Yes.
Is it made to the court?
Yes.
Is the letter addressed to the court?
Letter addressed to me, but that letter is being annexed.
You have to look into Allah, you have to take it in a true spirit, Mr. Counsel. We are deviating from the facts and we are not able to. Yes, if you want to go on technicalities, even we will go.
The fraud which is being played, that is a document which is annexed to the IMM file as annexes W.
Yes.
Annexure W with supporting affidavit. For that, IA is.
Sometimes what happens is we may have to give relief to the petitioner due to the submission of the respondents.
No, not like that. Based upon the facts and the law.
Please, madam. The lordship had heard this matter. I am very sorry for intervening in my letter. The lordship had heard this matter. This honorable court in the petition in August 2023 had said the lordship may see.
Correct. We said that union was to be made as a party at that point of time, and they have made as a party.
Yes, correct. Your lordship said the matter will be heard on the next day.
Correct.
Therefore, my lord, it is covered by a short question. Your lordship can see the prayer in the petition. The prayer is at each page number 30.
Yes, Mr. Datar. That he is a petitioner. So you have to address the petition. They have filed IA for vacating. Yes.
Now, I have challenged the scheme. I have challenged the
I
scheme.
think this petition was already disposed of in the earlier round of.
Yes. But these issues were not there. I had only challenged their circular in that. That is why if your lordship pleases tomorrow, your lordship can have it. I will place the petition before the Honorable Court. And I had challenged this contention that in their agreement, they had imposed the clause of 6 years vehicle. Life of vehicle should be 6 years. That is what I had challenged. There is no challenge to the scheme, city tax scheme.
No, but then when you had an opportunity to challenge.
You had an opportunity.
Challenge.
What your lordship says, I agree. But then the honorable High Court.
You did not challenge at the first instance there.
Correct. Your lordship, what you say is right. But that came as a part of their 1 minute. As a part of their statement of objections. That was given before the statement of objections, and they justified that this is in terms of city tax scheme. We are
How much time will you take to argue this matter?
Because I have to, maybe the challenge in the scheme and the Lokaita report, my lord. The
We will
Lokaita.
pass over, we will see after the other matters. Because there are other matters which are making.
Time, because Lokaita has also been, because the Lokaita is here passed. So Lokaita should be also before the Honorable Court. No,
Mr. Datta, now you want to implead everybody on the earth, everyone.
I challenge that. Yes, if we want to argue also, we are ready.
They're also there on record.
Yes,
So that
yes.
also impleading
Wait,
application.
you are not to kindly fix a date on Monday, we'll argue.
How can it be? Now they are ready for the argument.
It may be ready, Lord, because I was on this application, because here there is a violation of the High Court order, not to precipitate. And they are issuing a Suttole and circular saying that the agreement is coming to an end, therefore you have to issue fresh licenses. Well, already the license has been issued in terms of financial year.
Yes, what you say, Monday. Please, please serve the writ petition papers on the Lokaita. Whom we appear for respondent number 5. Counsel for the respondent number 5 submits that he is not in receipt of the writ petition papers. You want IAs? Writ petition papers and the IAs. Petitioner counsel to serve the entire set of the petition papers and the IAs on the learned counsel. Yes. List this matter at request on both sides on Monday. Yes. On the understanding that it will be heard on merits. On merits, Mr. Datta. Yes, yes. Interim order granted by this court stands extended.
Please forgive me, Lord, because that is the last day. Otherwise, my licenses, they will stop my vehicles.
Till the next date of hearing. Till the next date of. It has been continued.
Yes, they have not done it even when.
But then, see, when there is an.
It won't be done, madam.
Don't take any precipitated.
In fact, I will show, even though there was no legal obligation, only to the this was done. Because everybody has to survive. That was the reason. Anyways.
Monday.
And the amended cost agreement.
Sir, we have not implemented anybody now.
So that is here because the Union of India and
that I think on the last occasion we have made it.
Cost agreement.
Is amended constituted. I think we mentioned on the last occasion. And the IA was not allowed.
I think the IA was not allowed. IA was not allowed.
So then we have to allow IA. Which is that IA?
IA number 3, madam.
IA number 3. IA number 3 is to implead the Union of India, Alva. To implead respondent number, to implead Union of India as respondent number 6, 7, and 8. ASG, Union of India, Ministry of Civil Aviation. Union of India, Ministry of Road Transport and Highways. Airport Authority of India. ASG has been represented. ASG has represented respondent number 6 to 8. 6 to 8. Heard. Reasons indicated is accepted. I number 3 of 2024 is allowed. Petitioner to amend the cost title and file amended cost title by Monday. This is with an understanding that the matter would be heard for final disposal. Is Mr. Arvind? What is the office objections?
Is concerned. I provide typed copy at the time of hearing.
Readable, which is that annexure A. Annexure A. You don't want this court to look into that document at the time of preliminary hearing.
Copy at the time of hearing.
This is also a type of hearing, right? You say at the type of hearing, and now you don't want this court to look into that.
I provide. Further on, with regard to annexure G, not all the parties mentioned in annexure G have been made parties to this proceeding. So please see annexure G at page number 101. This order came to be passed on the application made by Muniappa and his wife.
This is an application filed by the respondent.
This was passed on the application made by Muniappa and Munidimappa. They acquired right under this order. So please see the last sentence in the order. ಸರ್ವಿ ಜಮೀನುಗಳಲ್ಲಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ ಇರುವುದನ್ನು ತೆರವುಗೊಳಿಸಿ ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ಪಹಣಿಗಳನ್ನು ಪುನಃ ಸ್ಥಾಪಿಸುವಂತೆ ಆದೇಶಿಸಲಾಗಿದೆ. I am concerned with this order. I want to acquire this property without payment of compensation to Muniappa and to Munidimappa. Others in this order are not necessary parties.
You have no relief against whom? Which are the in the submission of the counsel insofar in relation to office objections raised at serial number 2 and 3 is accepted in light of the submission that petitioner is not seeking any relief against respondent. 1 to 10 is as in the order at annexure G. Yes.
Typed copies are provided at the time of preliminary hearing.
Petitioner counsel undertakes to file the readable copy of annexure A and E within a week. Yes, now?
For preliminary hearing. Annexure E, A and E.
Yes. Now what next?
Please proceed for preliminary hearing.
List this matter in preliminary hearing. When do you want?
Tomorrow or after.
Monday. Petitioner counsel seeks time to rectify the office objection during the course of the day. Office to verify and proceed. All the matters 14, 15, 16, 17. Yes, yes, Mr. Lokesh.
After placing until time.
There.
But not to all the other.
Correct.
That is now operating. We will tell our
Then there's an order in your favor.
subsequent renewal, I am operating. Previous renewal against the previous
I thought objections are calling. Then file objection.
And the office objection now mentioned in
When you office objection comply ಮಾಡಿಲ್ಲ.
I've heard all the respondents.
Even if it is not made a part.
ಕೇವೇಟರ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ವಾ ನೀವು? ಯಾರು ಕೇವೇಟರ್ ಹೇಳಿ?
3 and 4. One went to government. 3 and 4. 3 is directed to take notice. Before this order was last case.
David was filed only by the court.
ARTC.
Affiliated to be made as a party in this. Yeah, the affiliated is called. The Northern State Transport. Be made as a party.
Two persons are before the tribunal, then person case artist.
Who is this Ravi Kumar?
We don't know. I sent the department as to I explained to this court.
Correct. You have to at least give a submission to that effect, right?
Submitted, it was not a party.
Elli there. Where is a note to that effect? You have to write a submission so that we can accept it, right? We alli en martira, we are not Mr. Consul. Mr. Consul, when you have something to be make this court to believe it, you have to make a submission, right? How are we going to assume that this is your submission? Why have you not made a Ravi Shankar as a party? That is what they say. So you give a note to that effect, we will accept your submission. You nodal then you namge helidre. You raise the voice to say that we have done it. Huh? Is it proper, Mr. Consul? See, when we have this order sheet before this court, registry says you have not given a note to that effect. How are we going to assume that you have given a note? You concerned worker jote en matadidra, we are not concerned. We are absolutely not concerned. Petitioner to rectify the office objections by the way.
Permission, I will say, write down here.
No, we have given you 1 week's time. Madi, comply, Madi. Yes, Mr. Prakash. Better copy of annexure D.
Sent to order passed for remarking a place as a road under section 71 of the Karnataka Land Revenue Act. So this document came into existence, not directly related to the area of issue in this.
Office objection raised by the registry at serial number 1 is overruled.
Yes. The challenge in this petition is the order passed by the respondent number 1 in the proceedings initiated by the respondent number 5 and 6 who are by neighbors. But the issue is this: they have raised that electricity connection which I have secured all along this road was demarcated long back in 1992. So they have started to contend that this land belongs to them. So the parallel proceeding is also concluded before the regional director of land records, and the order passed against me, subject matter of the petition before this honorable court, and this honorable court has pleased to pass the interim order by saying that. But what happened here? Kindly turn to page, the petition at page 48, annexure J. Invoking section 164 and section 17 of the 164 Electricity Act and the 17 of the Indian Telegraph Act. At page 48, they would have.
Yes.
So they having making the respondent authorities of the Transmission Corporation or the respondent 2 to 4 hearing. So the relief sought the indirect way against me. So what they challenge is the approval of the electricity provision for my estate is questioned here without making me as a party.
That is before the district magistrate,
yes,
right?
Yeah, before the respondent number 1. So I filed an application. I will come to know about this pending petition. Without assigning any reason, by cryptic order, the respondent number 1 has rejected the application. But if I have to draw my lord's attention to page 95.
So you have come before this court against the order passed against you in not impeding you in the proceedings.
Yes. Because any outcome that would go prejudice against the interest of the petitioner, the relief sought is against me.
Yes.
At page 97, the order dated 11/7/2024, just by one order, one line order, IA disallowed.
Who takes
Yes.
notice for the respondent?
Supervisor.
No, we have to state the order impugned.
For the proceedings
for
also,
the
for this reason, according to my instructions, the matter is in the stage of argument, sir.
Yes, sir. Who takes notice for any standing counsel appearing? Devraj.
Let's call.
And then the CGP to accept notice for respondent number 1. HV Devraju to accept notice for respondent number 2 to 4. Issue emergent notice to respondent number 5 to 6, returnable by. Learned counsel for the petitioner submits that the application filed by the petitioner before the district judge, Alva,
Respondent number 1, the deputy commissioner.
before the respondent number 1 has been rejected by a cryptic order and without any reasoning. And in light of the rejection of the application filed by the petitioner, the respondent number 1 is proceeding with the petition filed by the respondents 5 to 5 and 6. Next paragraph. In the circumstances made out, there shall be a stay of further proceedings pending before the respondent number 1 till the next date of hearing. Yes. You inform the concerned respondent number 1. Yes. Yes, what is the office objection? Huh? ಕೊಡ್ಬೇಕಲ್ವಾ ಕೇಬೇಟರ್ ಗೌರ್ಮೆಂಟ್ಗೆ ಕೊಟ್ಲಿಲ್ವಾ ಬೆಸ್ಕಾಮ್ಗೆ and what is that page 27 to be stitch readable ಮಾಡಿ ಅದನ್ನ ನಾವು ಹೆಂಗ್ ನೋಡ್ಬೇಕು ಹೇಳಿ petitioner seeks 2 days time to rectify the office objection. If office objections are rectified, this matter that we no Friday this court is not so good. Monday, Friday. Harsh Kumar Gowda. What is this? Blanks only antirala. That is the main thing. How are we going to look into the pagination part? Petitioner to rectify the office objections during the course of the day. Petitioner counsel submits that office objection will be rectified during the course of the day. Office to verify and proceed. Next, you know.
The petitioner is working as the man in the third respondent APMC. The application for the renewal of his license for the current year, my lord. The third respondent will issue the endorsement stating that it cannot be renewed because of the has lost the 60 years of age. The identical matters are pending and granted the interim order, my lord. The directed the petitioners to permit the function of the license of the actor E and F, my lord. The understand.
E and F.
E and F. Permitted the petitioners to carry on the I put copies at page number 20.
Earlier, which was the first order?
The annexure, may not be annexure F is passed.
Who takes notice for respondents? CGP to SCGP to accept notice for respondent number 1 and 2. Gopal Bilal Mane to accept notice for respondent number is directed to take notice for accept notice for respondent number 3. Learned counsel for the petitioner brings to the notice, draws the attention of this court to the identical matters where the interim order has been granted at annexure E and F. In order to maintain parity, the respondents are directed to permit the petitioners to function as licensed weighman in the third respondent APMC, subject to the result of the list this matter along with WP number 36860 ಆಮೇಲೆ ಅದರ ಜೊತೆ ಕನೆಕ್ಟೆಡ್ 35862 of 2016. Mr. Somsha.
We are for the petitioner, my lords.
Counsel for the respondent writes memo for retirement along with the acknowledgement to indicate that the respondent has taken back the entire case paper along with no objection. So the memo of retirement is taken on record. The learned counsel is Clifton Rosario appearing or Avani Chokashi is learned counsel is permitted to retire from the case. Registry to. But where is he? Is he here? Is he here before the court? Registry to delete the name of the counsel from the registry to delete the name of the counsel for the respondent from the cause list and show the name of the respondent. This matter after 8:41. 15:10.
Much obliged.
This we will close with respect to 9th respondent. Where is the memo? So you will delete that respondent number 6, right? Only delete. Nine, alva?
They have recruited.
Where is that memo of yours? Memo. Memo. This is their memo. Your memo ನೀವು ಹಾಕಿದ್ದೀರಾ? Your file affidavit. Yes. Affidavit. I know.
Along with the appointment order paper. Additional affidavit ಅಂತ.
Additional affidavit, hello? Respondent number 4 has filed additional affidavit on 27/8/2024, along with the copy of the appointment. Copies of the appointment order dated 14/8/2024. Issued to the 6 persons as indicated in the affidavit. The additional affidavit reads as under stack matter from para number. The relevant portion of the additional affidavit reads as under para number 4. The petitioner has filed the status report of the employees and indicated in the memo that respondent number 9 has absorbed all the 6 employees and they have reported for work. In light of the same, the proceedings as against respondent number 9 stands closed. KIADB stands closed. Yes. Now, respondent number 12. You have not given any further communication.
When we have told that we'll be absorbed, we'll be taking 4 persons on.
When did you file an affidavit? 3rd September. But then, what is the further action you have taken, and when will you take all the? No, you may say, you have to communicate, rather say, when will you absorb them? See, as they have done, KIDB have done, they have already issued the appointment orders. You say you want to take them, but you have not even issued an appointment.
So if they agree to the outsource basis acceptance, then we are ready to take that.
Yes. What do you say regarding the affidavit? Let them say anything about that affidavit. No, Rebecca.
And share the copy.
Now that you have filed, and now what about now? We got 19. Before 12, they have already filed an affidavit saying that they will outsource basis nalli togotaranta. When will you do that? That was the. You have said.
Because they have accepted the coming on outsources. So we are ready to take them.
Can you communicate madbekalla? Then what is next? Which one is that you're saying? Which is that thing? Who is respondent number 15? Respondent number 15 is consistently not present before the court. Who is the counsel appearing for respondent number 15? Respondent number 15. He has not even filed affidavit. They said they agreed to take 11 employees.
What we said, no communication at all that. Accepting other.
So the government had to say about it. They have said they have convened a meeting on 31/7/2024, wherein they have agreed to take 11 employees to litigate out of 11. In your affidavit, which is your affidavit? Hmm. So you have agreed. Respondent number 15 has to file an affidavit to the effect that when an appointment order would be issued to the respondent.
Yes.
We will complete this respondent number 15. Counsel appearing for the respondent number 15 is absent. Respondent number 15 has filed a memo on 8/8/2024. Stating that the government has convened a meeting dated 31/7/2024 and agreed to take 11 employees to respondent number 15. Pursuant to the memo filed, the state has filed affidavit of H.K. Shantraju, working as an undersecretary to Government Department of Commerce and Industries, CNC, to the effect that and at para number 7, as stated as under dated 6 August note filed on 6th August 2020. Not married. Memo from ಅದು ಇದು ಬಿಡ್ತಾರೆ ಅದೆಲ್ಲ ಕಷ್ಟ ಇಲ್ಲ ಇದು ಮಾಡ್ತೀನಿ. 24 11 work right? 11. Para 7 and 8. 7 and 8. Para 7 and 8. The respondent number 15 has not filed any affidavit indicating about further action taken by the respondent number 15. Respondent number 15 is directed to file affidavit to the effect stating as to when the orders of appointment would be issued to responding number to 11 employees. In respect of 11. Yes, next.
Respondent number 5. You have already filed an affidavit to the effect that 6 of them were deputed, 2 of them have retired, 4 of them have already been absorbed.
But
We filed an affidavit to that effect.
respondent number
5.
But you have not stated anything about respondent number 5. Right? So that you have no concern with this. So then we will not say anything about it. Then are they necessary in this party? Where is that affidavit of yours? For the affidavit, when did you file that? Date. So in light of that affidavit, you have no, your proceedings against respondent number 5 would be closed.
Same order number 22, one employee was deputed in BWS. The board said we could not.
So they have not agreed by that.
Not also.
How many employees have been sent? 6.
So that two are already retired.
2 are retired. And what about the other 3?
4 have been
4 have been observed. Respondent number 5 has filed affidavit statement of facts. Statement of affidavit, yaar the affidavit hakim. Statement of what? And the facts has been by affidavit of CN Manjunath, working as a general manager, A&HR, Bestcom, stating that pursuant to the order dated 26/10/2023 of the first respondent, the respondent number 5 have taken steps to observe the following employees of Mysore paper mills who were working with the said respondent. Para 2 Manu, Shri Narsimha Murthy PV. To get it in this. Affidavit of statement of fact, right? Dated 1/4/2023. Of respondent number. कितना बताना? Yeah, one. And further, that from the above said employees, 2 employees have retired and have attained the age of superannuation, namely Narsimha Murthy TV and K. Sharini on 36/2019 and 31/1/2022. And in its board meeting, the respondent number 5 have decided to observe the following employees with the pay scale. Extract map. Page 3. 1, 2, 3, 4. Along with the facts, the absorption of the employees at annexure R1 to R4 are produced. Learned counsel for the petitioner. Yes, what do you say, Mr. In light of the absorption, now you don't have any, we'll close the proceedings against respondent number 5. Learned counsel for the petitioner submits that in light of the absorption of the employees as indicated in the statement of facts, the petition against respondent number 5 be closed. Accordingly, the petition is closed against respondent number 5.
Hello.
One second. 9 is over. 12. 15 is over. And then
Sir.
cover.
Respondent number 13. Respondent number 13, there is a memo filed by respondent number 13, that is KVTSTC members on 3rd of June. 3rd of June 2023 members. Observing 7 employees of MPM vide communication dated 28/3/2023 members.
We have not stated anything about this respondent number 13 as well.
The last time it was not mentioned, my lords, but there is a memo filed by respondent number 13 on 3rd of June 2023, which is on record of this honorable court, where we had filed a memo. Probably it has got missed out in the whole process of many orders being passed, my lords.
Counsel don't appear, then what should we do?
My lords,
They should make a submission as to which affidavit they have filed, right? How many affidavits you have seen the file? It's only increasing with affidavits.
and I'm aware of the whole this thing being in a.
Yes, now you have to say what is the affidavit filed by you to what effect?
On 3rd of June 2023 is an affidavit memo filed by respondent number 13, my lords. Let's find that.
Do you have any grievance against that?
It states that 7 employees have been.
Just a moment, Mr. Counsel. Just a moment. Just a moment.
Sorry.
No, now, in light of the other authorities being made as a party here, they have to say that as to why they have been made as a party, correct? So we will say the petition is restricted only in respect of so and so respondents. See, now when we say the petition is closed, that is what now the order has been passed. Petition is closed in so far as petitioners numbers 5 and respondents number 5, 9 and all. It has been, that has been now done. So 9 and 5 have been closed. Okay. Now your grievance is only 12, 15, 17, 19 and 24. Then if you have no grievance against the other petitioners, other respondents, no, that's why this court said you give a memo indicating everything. You have only restricted, this adds to the confusion of the. No, without any material, we will not take this because this has already led to so much other consequences now.
Others are the portfolio, others are the core. They are already working in various roles of education. Out of which some of them have been absorbed, some of them have been continued. So pertaining to the livelihood and economic is protected, pertaining to the 120, only thing is that things whether they have to be absorbed or continued in existence. Present process which is going on is pertaining to the 52 employees who are not at all educated or put to be very important or proper. And based on that, various orders are passed. How exactly these so without employment, government is according to the orders of and government of which are the most important.
Yes.
And based on their own affidavit, we have given the
When others are already absorbed, then why are you making them as a party? Why they have to come to the court? You say against whom you have no grievance. See, all of them come with one affidavit. So the petition refers to 129 workers, right? No. So 209. Now you are concerned only of this 52 workers who are not been deputed anywhere. So we will restrict only to this and say what is their other grievance you have no against anybody. Then what is your prayer in this writ petition? Closure Admalik, now they are already been deputed somewhere, alva. You see, you are saying that the closure itself is not proper. See, now, when having, your
Then, if before December will go, then on a humanitarian ground, if these people can be accommodated somewhere else, it's closed. We cannot give appointment there. So if these people can be given appointment somewhere else, then it can be. Then what has happened? And these things were done. Now once again they are coming for provision, challenging.
See, once you are employed, once the court is taking you into action and saying that go and join somewhere, now you cannot say that no, that closure itself is bad. And now, in the event this court holds the closure is proper, what happens? What happens? So that is what this court is doing now. Once if this is done, where is the question of arguing on merits of the matter? After ಎಲ್ಲ ತಗೊಂಡ್ಮೇಲೆ ನಾವು ಮತ್ತೆ closure ಮೇಲೆ argument ಮಾಡ್ತೀನಿ ಅಂತ. Anyway, now see, you have only grievance against this 9 to 24. Whether our please you restrict yourself only to this respondents who are not been deputed or anywhere appointed. Yes. If I
don't know.
The petitioner has filed a memo stating the status of the employees who are without employment. Status of the 52 employees who are without employment, which reads as under statement dated 5/9/2024. The respondent number 12. Where is he? He already left. 12 outsourced. Outsourced. Why did he go? We are still in the midst of this petition, right? How could he go? Although we have already said about 12 ಅಲ್ವಾ? 12 ಹೇಳಿದಿರಾ? 12 ಹೇಳಿ. Have we already dictated regarding 12? 12 is over. Respondent number? First. Now 12 is over, 19 is over, 15 is over, 5 is over. 17, what about 17? No. 84 workmen are interviewed but no further communication. When you have filed an affidavit? Yes. Have you stated in your affidavit when will you file that? When will you take this persons into employment? You file an additional affidavit. Respondent number 17 submits that an additional affidavit would be filed to the effect as to when necessary, as to when the appointment Shall we say so? So that you have to do the process, right? As to when the process of appointment would be completed. Will you file that affidavit? Entire process would be completed. Have you what have you said in your earlier affidavit? Read that earlier affidavit. ಇದು ಕೊಡಿ ಅವ್ರ್ದ. Respondent number 17. Give the copy of it. Affidavit, when counsel for respondent number 17 submits that the respondent number 17 would file additional affidavit as to the present status of the four employees, allotment of 4 employees by next date of hearing. Respondent number 17 and respondent number 24 on top of it. Government focus. 17 ಆಯ್ತಲ್ಲ? 17 and 20. 24 ಮಾಡಿ. See, Mr. Consul, you have said 5 plus 3. 5 is already recruited and 3 has to be, let him file an affidavit what has been done to 3. Respondent number 17, I know. I mean, what about 17, 19? 19? Have they filed any affidavit? 19 have filed affidavit? No, affidavit. Counsel, who is the counsel appearing for the affidavit? Counsel appearing for the respondent number 19 is not present. The affidavit to be filed by respondent number 19. You kindly communicate with the respondent number 19 to the effect about the status of the 4 employees to be absorbed by respondent number 19. Next. Respondent number 24. Learned counsel submits that an affidavit would be filed stating the status about the 3 employees to be absorbed by respondent number 24. Yes. 5 is not in dispute, so only 3 affidavits of the respondent number of the said respondents to be filed by next date of hearing. What is this? We have no issues with respondent number 14. So this will only add to it now. He is having only grievance about this 52 workmen. So you keep it, you file it in the counter. Otherwise, again, it will give another list this matter in the week commencing from 21st.
Take one submission, my lords. My lords permits. My lords, as I mentioned.
For the next Not before this.
23, a memo of response. He was 13 was filed, my lord, which has not been taken on record.
ಎಲ್ಲ ಕೂಡ ಮುಟ್ಟೆ ಬಿಡೋಣ ಕ್ಲೋಸ್ ಅಂತ ಮಾಡಿದ್ದೀವಲ್ವಾ.
And if I'm not wrong, my lords, on the earlier occasion, this court had also directed the petitioner to file a.
Yes, what is that? Yes.
My lords, I was only submitting, my lords, that on the earlier occasion, this court had directed the petitioner to file a tabular column in a tabular format of how many employees have been taken in by.
He has filed in respect of 52 employees.
Rest of the employees be brought in, my lords, because otherwise.
You want to file affidavit memo in respect of all the employees. Yes, let him file that. Petitioner also to file a memo in a tabular form regarding the status of all employees.
So it becomes
in excess of hearing. And now what is yours? See, he has no grievance against, so he'll file a status report now in respect of others, then we will delete everybody. Let him file that. He should have filed 52 employees anta hinge heli, other employees what is the status anta heli, deputation alla. Yes, you file it.
In spite of bringing to the notice of the electricity supply company that certain persons have taken the law into their own hands.
Now, what is the direction they are seeking for? This court ನೀವು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತೀರಾ?
They obtained the connection on the basis of the order passed by this man. We were not main parties despite being aware that we are the persons who are objecting for that on the ground that we are the persons who have been allotted sites under the authorized scheme. We are the persons to whom sites have been allotted under authorized scheme. With the support of the, I may say, with the support of the MLA, who is bent upon doing some activities, they filed application stating that we have unauthorized the constructed houses on the sites which have been allotted to us, which cannot be countenanced under any circumstances at all. On the application made to the termination of the electricity supply company, we filed objection stating that the matter is seized by the High Court in another connected litigation. Please do not give any electricity supply to these persons. On that basis, unactually, endorsement will be issued.
And now what is the order passed by this court?
This honorable court, because this honorable court was not informed of our claim of the allottees under the authorized scheme, without making us as a party, issued a direction to termination electricity supply company to supply the electricity under the Gratuity Yojana.
Then you filed a review petition.
Then I filed a review petition. We did not get fit to the order.
We did a starting, we have completed. Number two, seeking a direct.
Yes, connection illandre where is the question? We will record a submission that there is no connection provided. So the question.
Certain persons taking undue advantage of the order passed by the court have illegally got connected. Illegally, without, I do not know whether it is with the assistance of the community or otherwise. That can't be done. In fact, I have produced those documents also, wherein we have made representation to electricity supply company.
This is the document you have produced.
The application which R6, R7 and R8, CH-17 and right side letter, a connector R7, page 18. You are the, sorry, not the assistant. Letter to the assistant executive engineer, August 2024. Page 8, I'm sorry, 18, connector R7.
They say that there is no temporary connection given by them. Do you say so? Any, you have not given any connection, file an affidavit to that effect. An application is filed by the petitioner, by the respondents, 4 to 19. Directing the respondents 1 and 2 to forthwith take action to disconnect the temporary power supply made to illegal temporary sheds of the petitioner on the property of these respondents. Learned counsel appearing for the Chescom, H.V. Devraju submits that the authority has not provided any connection, any service of installation to the petitioner as contended by the respondents 4 to 19. The said submission is taken on record. Learned counsel to file an affidavit to the said effect by next date of hearing. List on. When do you want? This matter in the week commencing from 21st. What is your name? You have filed wakalat. So-and-so counsel submits that he has filed wakalat for the petitioner along with KP Guvan. Registry to indicate the name of so-and-so counsel in the cost list. Have you carried out amendment? Amended cost title has to be filed. No, you have to file the amended cost title. Petitioner counsel submits at the first half. Petitioner counsel submits that amended cost title has been filed in the registry. Registry office to verify it. When was the interim order issued? And it's until the disposal of this petition.
I have actually
I-1 of 2024 in all the petitions is sought to seek for dispensation of production of the certified copy, production of the original bar certified copy. Then it counsel for the petitioner to submit that the that the original, what have you filed? Certified copy of Annexure A has been furnished. In light of the same, IA number 1 of 2024 in all the petitions stands disposed of. SCGP seeks time to file statement of objections as a final chance. 2 weeks time is granted. Is this matter immediately after Dasara vacation 2020? In the week commencing from 21st. Yes, what happened, Mr. Gautam?
Appear for the respondent, my lords.
They are agreeable to the terms. Why don't you give them a relieving letter?
My lords, relieving letter. My lord, she's gainfully employed. My lord, how did she get an employment there without a relieving letter?
Right. They would always insist for giving a relieving letter.
But
right?
how did she get an employment there now, my lord?
No, we cannot question that right now.
Okay, my lords. I'll just talk to the management, my lords.
Why
And I
should you-
filed a memo.
When somebody is not interested in your office, you should just leave them. Let them live their life. Why do you want to go behind them? I will not give you, I'll not do this. You just leave them.
My lords, no, my lords, that is not the issue, my lords.
No, once you are settling, you settle it forever, right? Don't insist for
My
something.
lords, I had told them about the monetary compensation, my lords. This one
They are
I
agreed to that terms. They are agreed. You just give them the relieving letter.
I had filed a memo, my lords, that has.
Which is that memo?
21/9/2024, my lords.
You are agreed for that, right? They have agreed for that amount. They have agreed. You just give them a relieving letter now. I don't think there should be any obligation. Now, when towards full and final settlement means you have to give them a relieving letter, whatever it is.
My lords, but it was not a case. My lords, it was not a case of resignation, my lords. She was terminated from service, my lords.
Correct. Yes. Just a moment. Is it not when you are settling her claim towards full and final settlement? This will, in fact, solve all the problems. Give her a relieving letter. Yes. When will you do that? Tomorrow?
My lords, tomorrow, my lords, I'll ask the management and get back to your lordships, my lords.
No, you file a joint memo that you will be giving a relieving letter to her forthwith.
Please, my lords, it may be added 2:30, my lords.
On the joint memo. File a joint memo. You you share it with the clause that they will be giving you a relieving letter forthwith, and towards full and final settlement, this is the amount you have. So then there be a joint memo which is duly signed by the petitioner and the concerned authorized officer of the respondent. Friday, this court is not sitting on Friday.
My lords, I'll inform this honorable court by 2:30.
Tomorrow.
Much obliged, man.
Tomorrow, file a joint memo to that effect.
Please, my lords.
Yes, Mr. Hasyagar. ಇದೆಲ್ಲ ಡೇಟ್ ಆಗಿಬಿಡುತ್ತಲ್ವಾ
Please.
How much cost you want us to impose, Mr. Hasyagar avare? Helbidi. Abuse to such an
I would only submit that this is a cause in which the appellant has got to fight out the litigation.
No, there is no cause, absolutely no cause. Even assuming that the signature is being verified, even if it is wrong, even according to you, we hold that the court could not have compared its signatures. Even in that circumstances, there were so many other circumstances which prevailed upon the court to come to a conclusion that there was no agreement.
I would note, having regard to the
Ask.
substantial questions of law
We will answer all the questions.
that Krishna Das disposed of the property in the teeth of the status order granted by the
You
court.
can imagine a situation where a landlord would enter into an agreement with the tenant whom he was going against for so many years. For so many years. And we appreciate your argument, Mr. Hassegar,
Please.
for protecting this tenant. Alva,
The purchaser in possession.
purchaser, not purchaser. He has failed to prove that he is the purchaser. Both the courts have held that agreement of sale is not proved. And it is a fabricated document. Correct. How much cost you want to impose? This is a perfect case of abuse of process.
She is a poor lady.
Poor lady and staying in the premises without rent for so many years. We are with poor lady, but not into such an extent where they abuse the process of law.
40,000 rupees she has paid as
Yes.
per agreement.
If you undertake to file some affidavit to the court saying that you will vacate the premises within so much time, we will not impose cost. But otherwise, we are going to impose cost.
And Anna, my client is not here. Innೊಂದು next week ಯಾವಾಗಲಾರು ಒಂದು ತಾರೀಕು
Next week ಅಲ್ಲಿ vacation, Mr. See, if your client is ready to vacate the premise, otherwise until she'll be driven out in the accordance with the opposite decreed. This is just to say that if you are staying in the premises, you vacate by taking some time.
ಅಂದ್ರೆ ಕನ್ಸಲ್ಟ್ ಮಾಡದೆ it may not be proper on my part to make any submission.
Anna, you must have asked her, right? That how much time you want to vacate, or did you not ask her any time?
No, she was confident that her appeal will be
100% permanently she would be residing there. Yes. That's all. We will go on merits then.
Yes.
Assailing the concurrent findings of facts recorded by the courts below. In OS number, concurrent findings of the courts. RSA 8 of 2016 is preferred by defendant number 1, Srimati Radha. Against the concurrent findings of the courts below. In RA whereby the suit of Sarojamma in OS number 318 of 1999 was decreed directing the defendant Radha to hand over the actual vacant possession of the suit scheduled property. Next. RSA 9 of 2016 is preferred by Radha, plaintiff in OS number 507 of 1997 against the concurrent findings of facts recorded by the courts below, whereby the suit of the plaintiff Radha for specific performance of contract was dismissed by the courts below. Parties herein are referred to as Radha, Krishnadas, landlord, bracket money, and Sarojama. And as per the rank in OS number 507 of 1997 as Radha as plaintiff, LR of Krishnadas, Deepak as defendant number 1, LR of defendant number 1, and Sarojama, bracketly plaintiff in OS number 318 of 1999, bracket complete, defendant number 2 in the defendant number 2. Next. This court, while admitting the appeal, on 7/12/2016, framed the following substantial questions of law. Sheets as a the counsel for the appellant and the learned counsel appearing for the respondent have been heard on the substantial questions of law framed by this. Learned counsel appearing for the appellant would urge the following points. That did we frame any additional substantial question of law? Additional ಏನ್ರ frame ಮಾಡಿದೀವಾ? ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ IA 1 of 23 ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ ತಾವು ಮಾಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರಿ ಅಷ್ಟೇ.
During the course of argument, during the course of argument, the following substantial question, additional substantial question of law is framed by this court. Whether the first appellate court judgment is in accordance with Order 41, Rule 31, CPC. Learned counsel for the appellant and the learned counsel appearing for the respondent have been heard on the substantial questions of law framed by this court and the additional substantial question. Learned counsel for the appellant would urge the following ground: that the first appellate court judgment is not in accordance with Order 41, Rule 31, CPC, as the first appellate court has not framed the proper point for consideration, and non-framing of proper point for consideration has resulted the judgment deviating from the factual aspects. Next. Exhibit D8, the agreement of sale executed by late Krishnadas was due to the financial difficulties which was faced by Krishnadas and which is categorically admitted by his son Deepak in his cross-examination, which aspect has been totally ignored by the courts below. That the reasons assigned, next, that the reason assigned by the trial court, kindly be seated, that the reasons assigned by the trial court to reject Exhibit D8, the agreement of sale is by comparing the signatures of Krishna Das on the disputed agreement of sale, Exhibit D8, with that of the other documents, that is Exhibit P1 and 2, without the help of the experts' evidence and the comparison of signature by the trial court with the naked eyes was not permissible. Not permissible. Are the judgments? The character with naked eyes was not permissible. Was not. In accordance with law, as the court should not take up the responsibility of comparing the disputed signature or handwriting with the admitted signatures or handwriting unless a report is solicited from the expert, and such an examination requires scientific exercise. That the trial court and the first appellate court has committed serious error without appreciating Exhibit D8 in a proper manner, that it is an agreement of sale executed by said Krishna Das, and the appellant has continued to be in possession of the property as she is the daughter-in-law of the erstwhile tenant Sri Kartige Gupta Swami. That the suit was filed by the plaintiff. Suit was filed in the year 1997 itself by Radha. But during the pendency of the suit, the Krishna Das has sold the property, and the trial court has not considered the effect of Section 52 of the Transfer of Property Act. In support of his contentions, learned counsel has placed reliance on the following decision. Alka Bose versus Paramatma Devi and others. Versus Paramatma Devi and others. Reported in AIR 2009 SC 1527. Which are the main citations which you rely? 2000? ಯಾವ್ದದು? ಅಲ್ಲ, which they are relying. Mr. Hasigar ಅವರ
Please.
ಕರ್ನಾಟಕದಲ್ಲಿ ಯಾವ್ದು ಮಾಡ್ತಾ ಇದ್ದೀರಾ? 1996
AIR 2000 ಅದೇ ಅಲ್ಕಾ ಬೋಸ್ ಆದ್ಮೇಲೆ AIR 2008 SC 1541 ತಿರುವೆಂಗಡ ಪಿಳ್ಳೈ.
ಅದು ಎಲ್ಲಿ ಯಾವಾಗ ಹಾಕಿದ್ದೀರಾ ಅದನ್ನ?
ಅದನ್ನ ಹೇಳ್ತೇನೆ ಎಲ್ಲ 16/2 ಹಾಕಿದ್ದು.
ಅಲ್ಕಾ ಬೋಸ್ ಆಯ್ತಾ? ಆಮೇಲೆ
ILR 2015 KR Karnataka 520 that is filed on ಅದು 16/2 ಸೀರಿಯಲ್ ನಂಬರ್ 3 ದಲ್ಲಿದೆ. ಆಮೇಲೆ
ಒಂದ್ ನಿಮಿಷ. AIR 1996 ನೋಡ್ಕೊಳ್ಳಿ, ಇವೆಲ್ಲ ಇದೆಯಲ್ಲ ಅಂತ ನಾವು ಡಿಕ್ಟೇಟ್ ಮಾಡುವಾಗ ನೋಡ್ಕೊಂಡು. ಭಾರತದ್ದು ಭಾರತ 1996 SC 1140.
ಹೌದು.
ILR 2015 Karnataka 520 Chidananda Swami versus Bellary. Chidananda Swami Bellary and another versus Shadakacharya. ILR 2015 ಅದು footnote. ಆಮೇಲೆ 2010 Part 3 MLJ.
ಹೌದು. ಆಮೇಲೆ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ RFA 885 of 2006 14/7 ಫೈಲ್ ಮಾಡಿದ್ದು. RFA 885 of 2016 14/7/23 it has been filed.
365 ಅದು ಯಾವುದು? ಎಲ್ಲ
14/7 ಫೈಲ್ ಮಾಡಿದ್ದು.
contra the learned counsel appearing for the respondent, justifying the judgment and decree of the courts below, contains that urge the following grounds. That Exhibit D8, if looked into, its recitals are taken into consideration. It is as good as an unregistered say deed, and therefore it cannot be construed as an agreement. That the question of any agreement in favor of the appellant or the tenant or the father-in-law of the appellant by Krishna Das would not arise as the father-in-law, alva? No. Appellant's Radha's father-in-law is tenant, right?
ಹೌದು.
ಕೃಷ್ಣದಾಸು ಫಾದರ್-ಇನ್-ಲಾಗೆ ಏನು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡೋದು ಬರಲ್ಲ ಅಂತ. ಏನಾಯ್ತು?
In favor of the appellant or the father-in-law of the appellant by K. Krishnadas,
as the Krishnadas had initiated HRC proceedings which had come up to this court, and the tenant having failed in the proceedings, has created an alleged agreement at Exhibit D8. That the courts below have not committed any error in declaring the suit of Sarojama or dismissing the suit of the appellant Radha, and the concurrent findings of facts does not warrant any interference by this court, and the substantial question of law framed by this court needs to be answered against the appellant. This court has carefully considered the rival contentions urged by the learned counsel for the parties and perused the material on, including the original bill. We'll continue the argument.
Submission with the Lord's kind leave.
23. Yes. No, that will take much time, Mr. Yes, Naik. ಅವ್ರನ್ನ ಕರಿಬೇಕು ನಾವು, ಅವ್ರು ಬರ್ಬೇಕು, ನಾವು ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು. See, we'll be going somewhere else. ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ಬೇಕಂದ್ರೆ ಕಷ್ಟ ಆಗ್ತದೆ. You know, further hearing ಆದ್ಮೇಲೆ ಅದು ಮತ್ತೆ ಬೇಡ. If in the event it doesn't get succeed in before the next roster, you can come back again. Yes. When do you want? After the Dasra vacation? Huh? Yes. After Dasra vacation, 2024. Yes, Mr. Sachin Mahajan, what is that?
My lord, your lordship had heard one matter, and my lord, there was advice for the parties to settle the matter. Now, my lord, 7486 of 2010 pertaining to Kalburgi bench, my lord.
It was parted, but in part.
Yes, my lord. Yes, my lord. The parties have settled the matter. Compromise petition is also filed, and my lord, the entire papers transmitted to my lord Bangalore, where the file is, my lord, at present.
So when do you want the matter to be listed? Are you coming before this court? Will you come to before this court in the presence of both the parties?
Parties, my lord, if lordship permit, my lord, they will appear through VC con, my lord, in Kalburgi bench. They will be identified by, my lord, us. Because one of them, my lord, is almost 94-year-old. So it will be difficult for him, my lord, to come to Bangalore. Yes. Since, my lord, the compromise
petition the dispute regarding that passage of half.
No, my lord, right? This is not regarding passage. The, my lord, fractured, my lord, piece of land in which, my lord, parties were fighting for one particular piece of land.
Overlapping.
Yes. Not precisely overlapping. This was, my lord, prior partition was needed.
And I think one party
had objected.
And one party had objected when he had.
Yes, precisely.
Yes, when do you want?
Friday, if it can be taken up, my lord, the parties will be present at Kalburgi bench, my lord, on VC, if it can be recorded, my lord, because they have signed and, my lord, papers are transmitted to Bangalore.
On first.
Friday, if it is possible, my lord, at 2:30.
Friday, this court is having. It's not possible on Friday. Either tomorrow or on first. On 1st October.
First, your lordship. On first, my lord, at 2:30, my lord.
First at 2:30.
Yes, my lord. There is also one more matter where there is an application for correction of judgment.
You just provide the number, RSA number, to the court officer so that he will.
Please.
Yes, what?
Highly obliged.
Yes.
Great.
30. Yes, at request of the petitioner counsel, list this matter after the vacation. No, separate list.
ನಂಬರ್ ಹೇಳಿ ಸರ್.
Sir, RSA number, regular second appeal number 7486
ಆಫ್
2010.
2010. ಓಕೆ, ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲೇ ಇದೆಯಾ ಸರ್?
ಸೊ ಇಲ್ಲ, ರೆಕಾರ್ಡ್ ಗುಲ್ಬರ್ಗ ಇಲ್ಲ, ಬೆಂಗಳೂರಲ್ಲಿ ಇದೆ. ನಾನು ವೆರಿಫೈ ಮಾಡಿದ್ದೀನಿ, ಬೆಂಗಳೂರಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಮೇಲೆ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇಲ್ಲೇ ಫೈಲ್ ಅದು ಕೂಡ ಅಲ್ಲಿ ರೀಚ್ ಆಗಿದೆ, ಟಪಾಲ್ ಜೊತೆ ಬಂದಿದೆ.
ಅಲ್ಲ, ಇದು 10 ಯಾಕೆ ನಮ್ಮ ಮೇಡಮ್
ಪಾರ್ಟ್ ಹರ್ಡ್ ಮ್ಯಾಟರ್ ಇತ್ತು, ಅದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ.
ಓ, ಫರ್ದರ್ ರೀಡಿಂಗ್. ಓಕೆ ಓಕೆ ಓಕೆ, ರೈಟ್ ಸರ್.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಕರೆಕ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ, RSA 662 of 2007.
ಅದು ಮೇ ಬಿ ಆಮೇಲೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಇದನ್ನ ಮುಗಿಸೋಣ ಫಸ್ಟ್.
ಅಲ್ಲ, ಎರಡು ಒಂದೇ ದಿನ ಆಗೋಗುತ್ತೆ. ಸುಮ್ನೆ ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡ್ಬೇಕು. ಅದಕ್ಕೆ ನೀವು ನೋಡಿ ರಿಕ್ವೆಸ್ಟ್ ಮೆಮೊ ಮೇಡಮ್.
ಅಲ್ಲ ಸರ್, ಅಲ್ಲ ಅದು ಸಿಂಗಲ್ ಡಿವಿಷನ್ ಬೆಂಚಾ?
ಸರ್
ಸಿಂಗಲ್ ದೇನಾ?
ಸೆಕೆಂಡ್
ಹೇಳಿ ಸರ್, ನಂಬರ್.
ರೆಗ್ಯುಲರ್ ಸೆಕೆಂಡ್ ಅಪೀಲ್ 662 of 2007. 2007
ಇದು ಬಂದಿದ್ಯಾ ರೆಕಾರ್ಡ್?
ಅದು ನಾನು ವೆರಿಫೈ ಮಾಡ್ಕೊಳ್ತೀನಿ, ನೀವು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾನು ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ಫಾಲೋ ಅಪ್ ಮಾಡ್ತೀನಿ.
ನಾನು ಹೇಳ್ತೀನಿ ಸರ್, ನಾನು
ಅದು
ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀನಿ.
ಇದು 7486 of 2010 ಅದಂತೂ ಖಂಡಿತ ಬಂದಿದೆ ರೆಕಾರ್ಡ್.
ಶೋರ್, ಓಕೆ ಸರ್, ಅದ್ ನೋಡ್ತೀನಿ ನಾನು.
62 of 2007 ನಾನು ಸ್ವಲ್ಪ ಫಾಲೋ ಅಪ್ ಮಾಡ್ತೀನಿ.
ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಥವಾ ಮಾಡ್ಬೇಕಾ?
Petition duly signed and filed is also transmitted to that.
Okay sir, okay
sir, thank you very much sir.
Bill number 18 ಕೊಟ್ಟರೆ ಮಾಡ್ಕೊಡ್ತೀನಿ ಸರ್. ಫೈಲ್ ಡೀಟೇಲ್ ಹೈಕೋರ್ಟ್ ಬರಲ್ಲ ಸರ್. ಸರ್ ಕಾರ್ಡ್ನೇ ಇಲ್ಲ, ನಾನು ಅವ್ರಿಗೆ
The facts that needs to be stated here. Case number P18 of 1999 was filed by Sarojama seeking possession of the suit schedule property on the ground that she purchased the suit property under the register say deed dated 9/12/1998 pursuant with an agreement of sale dated 14/5/1995 executed by dependent number 2 Krishnadas. The suit schedule property was acquired suit schedule property. The Krishnadas acquired the property by register sale deed dated 2/2/1970. In the said suit was number 318 of 1999. The plaintiff Sarojama instituted suit in OS number 7 against R. Radha and Krishnadas. R. Radha plaintiff in OS number 507 of 1997. The dependent number 1, Radha in OS number 318 of 1999, filed OS number 507 of 1997, seeking for specific performance of the agreement of sale dated 14/5/1995, alleged to have been executed by N. Krishnadas. For a sale consideration of rupees 70,000 and an advance amount of rupees 40,000 was paid to Krishnadas. In the said suit, the plaintiff Radha impleaded in the said suit, the suit was instituted by Radha against dependent against Krishnadas, and on his death, his LR Deepak was brought on with her and against Sarojama. As the plaintiff Radha contended that under Exhibit D8, the agreement of sale by Krishnadas, possession was delivered to the appellant. And during the pendency of the execution case, as per the agreement of sale, possession was delivered to the appellant. The Krishnadas instituted HRC proceedings against the father-in-law of the appellant, namely Pettige Puttaswamy, in respect of both the properties. In HRC number 146 by 1992 and 147 of 1990. The said petitions were allowed. Against the said decree, the tenants preferred revision petition in RR numbers 94 of 94 by 84 and 96 by 81. The said revision petitions were also dismissed. As the tenants were in possession of the suit property and the adjacent premises and failed to deliver the vacant possession of the suit property, in spite of the decree in favor of the landlord, Krishnadas. Krishnadas instituted execution proceedings against the tenants therein in execution 13 of 1998 filed against Srimati Narsama and execution number 14 of 1995 filed against Pettige Puttaswamy, dead by LS in the execution. The plaintiff, the Sarojama and the Krishnadas contended that they had taken delivery of the scheduled premises to the court from the LS of Pettige Puttaswamy. And as per the delivery receipt dated 6/7/1985, and hence from 6/7/1995, the second defendant, namely Krishnadas, was in possession of the suit property till the date of execution of the sale deed in favor of Sarojama on 19/12/1998. The case of the Sarojama as well as Krishnadas is that after taking possession of the scheduled property and the adjacent property, the case 9/12/1998, the Krishnadas fought litigation from 1972 to 1995 for more than 2.5 decades. And after taking possession by the second defendant from the court Amin, the second defendant had locked up the scheduled premises. The plaintiff, who had no right whatsoever in the suit property, has trespassed in the suit property and breaking upon the law. She is now residing in the scheduled property. After the execution, proceedings were concluded. The agreement of sale was executed. Agreement concluded. The agreement of sale.
Second defendant locked up the scheduled premises. The plaintiff, who had no right whatsoever in the suit property, has trespassed the suit property and breaking upon the law. And she is now in the scheduled premises. After the execution proceedings were concluded.
Holding that the Krishnadas has obtained possession over the suit schedule. Sarojamma, who is the purchaser from Krishnadas, contended that the Radha is occupying the premises without any legal rights, and hence the suit was number 318 of 1999 instituted by Sarojamma seeking delivery of vacant possession of the scheduled property. The specific case of the plaintiff, Radha, is that there is an agreement executed by Krishnadas in favor of her father-in-law under an agreement of sale dated 14/5/1995, and she is in possession of the plain scheduled property as a agreement holder and sought for relief of specific performance of crime. The defendant, Krishnadas, filed written statement specifically contending and denying about the execution of any agreement in favor of the plaintiff's father-in-law, and specifically contended that he had initiated HRC proceedings before the competent court and had obtained decree in his favor. And when the plaintiff failed to vacate the premises, execution petition was levied and he had taken possession in accordance with law. However, subsequently, the plaintiff has illegally trespassed upon the property by breaking up open the lock, and she is now residing in the scheduled premises. And hence the suit by Sarojamma seeking possession. The trial court clubbed both the suits as number 318 of 1999 and 507 of 1997. And on basis of the proceedings, oral and document evidence, arrived at a conclusion that the plaintiff, Radha, has failed to prove that the first defendant has executed, Krishnadas has executed an agreement of sale dated 14/5/1995. That the plaintiff in OS number 318 of 1999 has acquired title over the suit scheduled property, and the plaintiff is entitled for possession over the suit property from the defendants. And by the judgment and decree, decreed the suit of the plaintiff of Sarojamma for possession and directed Radha to hand over the vacant possession of the suit schedule and dismissed the suit of Radha seeking specific performance. The first appellate court, while reappreciating and reconsidering the entire oral and documentary evidence, being the last fact-finding court, concurred with the judgment and decree of the trial and dismiss the appeals preferred by the Referred by rather. The main ground raised by the appellant is that the Exhibit D8 does not. Exhibit D8 signature that that the signature on Exhibit D8 has been compared by the court with the admitted signatures and on signatures with the disputed signature of Krishnadas. Next. It is true that the courts is not experts of experts under Section 73 of the Indian Evidence Act 1870. Section 73 of the Evidence Act under Section 73 of the Indian of the Act, the court has power to ascertain whether a signature, writing or seal is that of a person by whom it purports to have been written or made. Any signature, writing, or seal admitted or proved to the satisfaction of the court to have been written or made by that person may be compared with the one which is to be proved. Although that signature, writing or seal has not been produced or proved for any other purpose. And the court may direct any person present in the court to write any words or figures for purpose of enabling the court to compare the words or signatures so written with any words or figures alleged to have been written by such person. The court under Section 73 is entitled to make comparison of disputed and admitted signature for just conclusion. As a rule of prudence, expert opinion can be obtained. As a caution, the apex court way back in the year 1979, in the case of State Delhi Administration Company versus Pali Ram 1979 Part 2 SSC 158 has held in para number 30 that ordinarily it is not prudent for the court to ask the expert to give his finding upon any of the issues, whether of law or fact, because strictly speaking, such issues are for the court or jury to determine. The handwriting expert's function is to opine about the scientific comparison of the disputed writing with the proved or admitted writing with regard to the points of similarity and dissimilarity in the two sets of writing. And the apex court has cautioned that the court should not take up responsibility of comparing the disputed signature or handwriting, admitted signature or handwriting unless a report is solicited from the expert, since such an examination requires scientific access. This court has absolutely no quarrel with the settled proposition of law. However, the court can indeed compare the disputed signature with admitted signature to determine the authenticity. The trial court's decision to dismiss the suit is not only based on the signature to be in variance with the admitted signatures of Krishnadas, but also many other relevant facts which was considered by the trial court to arrive at a conclusion that the agreement was not genuine. And when the defendant disputes the agreement, the burden was on the plaintiff to prove, and burden was on the plaintiff to require to prove the existence of valid agreement for specific performance. The courts below, having found that no sufficient evidence is placed to support the evidence of such an agreement, the courts below, the trial court arrived at a conclusion that the agreement of sale alleged to have been alleged by the plaintiff is not proved. The one relevant fact that needs to be considered is that in the year 1972, the father-in-law of the appellant was inducted as a tenant. The landlord, Krishna Das, instituted proceedings of eviction by filing HRC before the competent court. The Krishna Das was able to get a favorable order in his favor, and the eviction proceedings were decreed, and the revision petition filed by the tenant Kattige Puttaswamy was dismissed. And in the execution, in EP number, the certified copy of the order sheet, the EP 13 of 1995, marked at Exhibit B9. B9 and P6. P6 and P9. Which is the relevant execution, 13 or 14? 13, huh? Exhibit D5 and ಅದೇ ಯಾವ್ದದು relevant ಯಾವ್ದು 13 or 14?
Execution 14 of 19. That is Kattige Puttaswamy.
And 13 is of that Shardamma. ಯಾವ್ದದು execution 13, huh? 13 of Exhibit P6. Exhibit P6 is the execution petition number 14 of 1995, filed by Krishnadas against Kattige Puttaswamy, instead by his Elas. And the delivery of possession was ordered by the executing court. And on 22/7/1995, Mahazar and delivery receipt was received, stating that the possession has been delivered to the decree holder. And on 22/7/1995, the judgment debtor, the LR of Katige Puttaswamy, was present. The alleged agreement is dated 14/5/1995. If an agreement, as stated by the plaintiff, Radha, is said to have been executed on 14/5/1995, there was no incumbent upon the judgment debtor to state that he has continued in possession of the scheduled premises pursuant to an agreement of sale executed in his favor by the decree holder when the execution petition was closed on 22/7/1990. There is not even a whisper in the proceedings, in execution proceeding, about an agreement, about the alleged agreement of sale to have been executed by Krishnadas. This is one of the aspects which made the trial court to disbelieve the contention and proof of alleged agreement of sale. The decision placed reliance by the appellant, this court, as absolutely no quarrel about the settled proposition of law as stated. As noticed by this court, the trial court has not only dismissed the suit for specific performance on comparison and not finding the signature of Krishna Das. That was one of the factors for the trial court to arrive at a conclusion. When considering all the aspects, the trial court held that the plaintiff has failed to prove any agreement of sale as alleged by the plaintiff. Regarding the sale of the suit property in favor of Sarojama, though it is contended that the sale was during the pendency of the suit. It is relevant to note that in a suit for specific performance, the claim of the plaintiff is against the vendor, that is defendant number one, Krishna. The plaintiff has to establish that there was an agreement of sale, and in the event he establishes that there is an agreement of sale, and the court comes to the conclusion that a specific performance has to be granted in favor of plaintiff. In that event, defendant and the subsequent purchaser have to come forward together to execute a sale deed. In the instant case, the courts below have arrived at a conclusion that the plaintiff has failed to prove the agreement of sale itself, and thus the contention of the plaintiff that the suit, that the sale deed is hit by Section 52 of the Transfer of Property Act is not available for the appellant. Not available for the appellant plaintiff. The The first appellate court, being the last fact-finding court, has framed, has analyzed the entire oral and documented evidence. And the exercise of the first appellate court and perusal of the judgment of the first appellate court would indicate that the first appellate court has followed the procedure as contemplated in under Order 41/37 and as contended by the appellant counsel, as rightly exercise is covered under Order 41/31. The apex court in the case of Santosh Hazare, perusal of the judgment would indicate, perusal of the judgment of the first appellate court would indicate that there is no illegality and infirmity in the order passed by the first appellate court warranting any interference. Relevant to state here is that the appellant is in possession of the property from 1970. The landlord was made to file an eviction suit against the tenant, and having failed to get a favorable order by the tenant in a dispute between a landlord and tenant, which was brought up to the revision, execution was levied by the landlord, where the possession was taken by following the due process of law on 22/7/1995. The tenant, having lost started the second innings by claiming that he is in possession of the property as an agreement holder. The matter is pending in the second round from 1995. From 1997, the landlord and the purchaser of the property is unable to get the fruits of the decree from the hands of the tenant. And it is high time that the courts should heavily come upon such type of litigations, where the tenants, in one way or the other, try to protract the proceedings, either by filing a third-party application or by saying that there is an execution of agreement of sale as contended in the present proceedings. This is a perfect case where the tenant has abused the process of law and making this court to impose cost upon the appellant. The substantial question of law proclaimed by this court has answered, state for the foregoing reasons, supra. This court does not interfere. The substantial question of law raised by this court is answered against the appellant. And this court passed the following order. The regular second appeals are hereby dismissed. The judgment and decree of the courts below stands confirmed. The appellant is imposed cost of rupees 50,000 to be paid to the legal services authority within a period of 2 weeks from the date of release of this order.
Imposition of cost may kindly be considered by the Sound Court.
You have to see from when you have been litigating very conveniently. If you deliver the possession forthwith, we will say that no cost. If you want to say that you will deliver the possession, you will not impose cost, but not otherwise.
28.
We'll give the operative portion of the order. Regular second appeal 292 of 2016 is hereby allowed. RSA 9. Yours is 9. The output. So sorry, this is another file. Pass the operative portion. Which is your appeal? RSA 970. 970 of 2016 is hereby allowed. RSA 10 and 11 of 2016 are hereby dismissed. The suit of the plaintiff is dismissed. So we will say on merits, no admission, no grounds made. With RSA 11 nulli, no grounds made for admission. RSA 10 is dismissed. We will look into it. But your appeal is allowed, their suit is dismissed. We hold that it is prior partition is there. Prior partition. And we will hold that it is a mortgage, but a sale, he has redeemed that amount, and as an individual, in his individual capacity because of the partition which was affected. And the exhibit P7 becomes, in light of his purchase, it becomes his absolute property. Then that will suffice, right? After he purchases the property. But no, because when you looked into the document, it is not conditional sale. No, if you look at the subsequent sale deed, which is executed in your father's name. No, we will answer this accordingly. Now, as per the suit has to be dismissed.
Relationship of debtor creditor.
No, what you say is he'll be always a mortgagee. According to you, in the event if this court holds that it is a mortgage with conditional redemption, because mortgage is always a mortgage.
They feel when will be able to lose them in the sense. What will happen?
But see, in a mortgage property, he cannot seek for partition. That is also there. He cannot even seek for partition in a mortgage. So we will answer that. We will answer accordingly. When we looked into exhibit first document, I felt that it is a mortgage. That's why this court said.
What will happen if it is co-owner? Or if Vikram Kalaya who purchased the property becomes a co-owner, the second whatever having held not one but two, is a co-owner. But Vikram will become co-owner by virtue of the P6. Thereafter, what he does, my lord, not relevant at all. Unless, my lord, once again you revert back to the family.
No. See, this way, it is simple. There is a mortgage by this Mariappa. Mariappa mortgages the property. For assuming you say it is conditional sale, now if you say it is a mortgage, 200 rupees was the mortgage amount. If he doesn't redeem, the mortgagee becomes he has to retain the property until he gives that amount. He doesn't give the amount. Mariappa doesn't come forward to give the amount. Partition is already affected. No, he pays the amount, redeems the mortgage, takes the property as an absolute owner.
If you take the property of the typical absolute owner, he is the co-owner, he is the absolute owner.
Absolute, because in light of the partition, absolute owner. That's all.
He is the absolute owner.
Then they will not get any right to seek partition in the property. We will see whether it is, but according to me, it is for mortgage.
Creating a security, it says it's my property. It is my car. I'm the owner.
Exhibit P5, no? Exhibit P6, whether a mortgage or a conditional sale.
Mortgage, the mortgage by conditional sale. Or my lord, sale with the condition to repurchase.
Mortgage by conditional sale or sale by condition to repurchase. We will answer that. Yes, yes. Yes, we will say. Yes. Mortgage by conditional sale. Other hearing. 230. Yes. Password. So client is in advice to the so he doesn't want.
Into the litigation by accepting.
And the Shaker is acting on behalf of a knight. Now modified, huh? You did the other day, right? So we'll take this memo, and in light of this, the order passed by the controlling authority and the appellate authority stands modified. Modified, holding that the respondent workman is entitled for gratuity as under. Not entitled for? Because we have not any order under 2A. So that also has to be stated here.
As far as 7 years is concerned, there is no he doesn't want an order or any issue. Therefore, he's restricted to play for 5 years. That's the point.
So we will just say, in light of this memo, his claim is so and so on.
Claim is only for 5 years. And as far as even in that 5 years, I am disputing. And that you are also making check.
The petitioner corporation is before this court assailing the order passed by the controlling authority, confirmed by the appellate authority. The ground raised by the petitioner corporation is on 2 courts. One, that the order of the authorities is erroneous as the gratuity calculated in terms of the regulation is erroneous as per the terms and conditions of the appointment of the third respondent, wherein it is clearly stated that the third respondent would be governed by the Payment of Gratuity Act as far as payment of gratuity is concerned, and hence the respondent claimed rupees 49,010 in terms of the Payment of Gratuity Act, while the authorities granted gratuity in excess of his claim, and the calculation made is erroneous as the workman is not entitled for gratuity, payment of gratuity in terms of the calculation made in terms of the gratuity regulations. 2. That the authorities committed an error in taking into consideration the period of service rendered by the third respondent as 7 years, as the evidence on record clearly proved that he was under suspension for a period of 216 days, 15 days of absence. In all, 234 days absence during the period of 2010 and 11. In the year 2012-13, he remained absent for 211 days and worked only 154 days, and therefore the total service rendered by him was less than 5 years. And therefore, the calculation made by the authorities that the service rendered by him is 7 years, 1 month, 14 days is erroneous and unjust. Insofar as the first contention is concerned, the third respondent has filed a memo restricting his claim, and that the gratuity to be calculated in terms of the Gratuity Act. And the gratuity payable is to be by taking 5 years of his service under the Payment of Gratuity Act. Insofar as the second prayer is concerned, insofar as the second prayer is concerned, the petitioner management wants to treat the break-in service of the employee. When a management wants to treat any period to be break-in service of an employee, under Section 2A, subclause 2 of the Gratuity Act 1972, an order, the management has to pass an order to the knowledge of the employee and in compliance with the principles of natural justice. Merely by deducting the period in its service register, it could not treat the same as break-in service. And in the instant case, as there is no order passed under Section 2A, subclause 2 of the Gratuity Act 1972, the said contention of the petitioner corporation is not available to be raised before this court. So far as the first prayer, the memo is filed by the third respondent. In light of the same, the gratuity as per the Payment of Gratuity Act, the workman is entitled for as under 12,334 into 5 into 15 by 26, 35,578. The respondent number 3 is entitled for gratuity of rupees 35,578 with interest at the rate of 10% per annum from 11/7/2013 to 31/3/2016, and the orders passed by the authority stands modified, and this court passed the following order. Writ petition is allowed in part. The third respondent is third respondent is entitled for gratuity of rupees 35,578 with interest at the rate of 10% per annum from 11/7/2030 to 31/3/2016. Yes. The respondent number 2 is directed to release the amount as ordered at operative portion number 2 within a period of 4 weeks, forthwith, and the remaining amount to be dispersed to the corporation. In senior jor argument, collapse ಆಗ್ಬಿಡ್ತಿತ್ತು. What's the serial number anyway? Yes. Yes, sir. Yes, sir. Age. Which?
Yes. Not be maintained. They themselves are producing revenue records from the index. So, after single stack of document, revenue document, to show that they are in position of having that ground itself is a not thought for possession at all. And there is no document evidencing their possession. This aspect of the matter, they have not been able to point out to the court, meet this contention that they were in possession of the car, except asserting it in the phrase. They have not been able to, in fact, in our amending exhibit P8. P1 to P12 are the only documents used to establish their title and to contend that they are in possession. P8 goes against the contention that they are in possession. P8 is a document index of land which discloses that the school is in possession of the property. That is survey number 40/12.
Exhibit P8 per se.
P8, which is index of land. P9, sorry, P9. Serial number 12 only. Copy, survey number 40 is in the letter.
Yes. Exhibit P9. See, the 4D was done on 18/11/1956. As per the say of all the people, all the persons. They say, that's correct. Statement is that we are going to give this property to the school. Is
what is my 50?
There is 54, no dispute about 54. So this, no. This is only regarding 40/12. So 40/12 in the 4D, which was conducted in the year 1956, exhibit B16. Correct. But there is an reference to the 4D which was conducted on 18/11/1956. And as per the statement by other persons, they said that this property, rather 40/12, would be given to the school. Pursuant to this 4D, that is 1956, there are the sale deeds which have been executed in favor of the vendor. That is 57, 58. These are the sale deeds from exhibit to D14. 15 is the later. So up to 14, these are the sale deeds. In those sale deeds, there is a mention, no doubt, about the school or towards the northern side. It is in light of the 4D which was conducted and the statement given by the person stating that. No, 56. No, 56.
No, D16 is a statement of recorded in 1919.
Correct. It was in light of the 4D. If you
maybe it's an additional statement made in 1990, which according to me, in law, that statement has nothing because
the reason for making or the showing the boundary to the northern side as the school was this until because there was no document even in your favor at that point of time to say that you were given this property by the commission.
The document issued for us, 40/12 is concerned, though I have mentioned an order of.
That is just an endorsement and you have not.
Now who has approached the court?
Correct.
The burden is completely on the plaintiff, completely on the plaintiff. Now, as I said, kindly take the boundaries. 40 now, remember, the document exhibit 7 is a composite boundary given for the entire. Now, will that boundary help in? My answer is no. Simply the same sheet contains 2 survey numbers which admittedly he does not possess any right. That is 40/1 and 40/6. 40/6 is also not found actually.
No, it's not that.
How can there be a composite boundary? For example, if I write a composite boundary, does it mean that I acquire all the rights within that boundary? It's not been able to show. Even 40/6 is acquired by him. How can there be a composite boundary? That boundary itself is 40 boundary. And how can 40/1 file mention at which he has no right to 40/1?
40/1 is
40/6.
That also is not available.
How can there be a composite boundary? Firstly, so P6, P7 boundaries does not help it. I have produced all the exhibits which are in my possession to assist the court. P15 is the in respect of survey number 40. Now I have extracted file a memo.
Yes.
Lordship compares the boundaries of P15
yes.
and the thin schedule property.
Yes.
Measurements, of course, does not tally. 3 acres 30 guntas and 2 acres 11 guntas is really difference of 1 acre 20 guntas. Last time I was told measurements in P7 also does not tally.
For P7.
P7 also. Total extent and the.
No, we calculated. It was tallying. It was tallying. See, no.
I'll have the one.
11 acres, 15 guntas was the total extent.
Now, kindly see the memo that I have filed.
Yes.
I have extracted D15, which I have, even on the last date I have submitted. It is not their case that 40 became 40/12. Not a single word of it in the plate. No evidence to that extent because there is no pleading. They have not approached this honorable court to say that 40 became 40/12. It's not their case at all. It is not even their case. Parent court go on to make a case for a part. That's first. Kindly see exhibit D15. Same date dated 15/6/1954.
Yes.
For survey number 40, measuring 3 acres 30 guntas, east by land of Sagudara Dodda Shantaya, west land by Chitta Rudraya, north by small stream. This is north by small stream. South by land of Jodidar Nanjappa. Now kindly see the plain schedule property. The third one. Plain schedule property. East is by road to Bethalli and Kadagari. Kindly see here, my lord. East is land belonging to Dodaya Shantaya. East does not tally, my lord. Even if they want to take advantage of the 15 for a moment, my lord, assuming that 40 is 40/12, at least boundaries must tally. East does not tally. West, Arkavati river, here west is land by Chikkarudraya. North by small stream, here north by small stream, that's the only boundary that tallies. South by land of Jodidar Nanjappa, here land of Raiti. How can there be a road to the eastern side? If the boundaries are the same ultimately, in D15 is what they latch on to say is survey number 40, assuming though not pleaded, has become 40/12. Boundaries at least must remain the same, if not the extent.
Yes.
Where does it tally? It does not even tally. And their own document which subsequently executed, which I have filed under order 41/227, also discloses even much after during pendency also. They say towards northern side is the land of the school. They admittedly don't have title, my lord. My question of pointing out, I can also place judgment to say, if two persons are in possession, or do not own title, assuming there is no endorsement, then the person who is in possession is. Now they have no right, which is the document, where is it mentioned that for survey number 40/12 belongs? Simple one question. They cannot need oral evidence to establish their right. That is not even their case at all. 40/1, despite being sold, gifted to the school is included in their salary at least. 40/6, although they don't own it, they give a composite boundary. Therefore, that safety does not have any credibility at all. I kindly see the plaintiff purchases in the year 1970. He admits in the course of cross-examination that he has not made any inquiry. Prior to the purchase of the property, he has not even made inquiry. He says, I was taken to the land and shown, and therefore I have purchased. I have believed. There's no inquiry. If school's name is shown in the revenue records, was it not included to make inquiries? 70, what he purchased.
What are the revenue records?
Exhibit B, I is the index of land. They themselves produce. Mere assertion that they are in possession as against long-standing revenue records. In fact, one division constitutional courts cannot turn blind eyes to long-standing revenue. These are presumptive value. This is their own document. Can we see exhibit B? See, to the left are all the survey number 1, 2, 3, 4, 5, 12. It shows in the 10th column.
Yes.
I showed DPI.
Yes.
This is his document. Now, where is any document to show is in possession? These are revenue documents which, of course, I cannot get title by virtue of revenue. Only a document should show who is liable to pay tax. But it's also a document to show who is in possession. Without seeking relief of possession, he has sued for declaration. It's not my name.
That is your main ground.
That's one of my main ground. Second is, the exhibit P7 is a composite boundary. And exhibit P7 includes two properties which admittedly they do not have any right over the power. So the boundary described in P7 also cannot be taken into consideration. This is my second submission. The third submission is exhibit D15, which I have produced. My production is latched on. Not to say the boundaries of D15 also does not tally with the plain schedule power.
Yes.
And their own scientists, subsequent scientists, where they disclose to the northern side, they could have said northern side is a land belonging to them. It's a registered document. They go ahead and register that document to sell it to others. They make a representation to the others that this is a land belonging to the school. Can they now decide upon that document when it suits their convenience? So therefore, it's not a question of my establishing title over 40/12. Their case, they have approached me to court. Therefore, the burden is entirely upon them, which they have made this. After all, this was correct. What plans have been given, promote education belonging to the private. And even the commissioner records
40 is 40/12. Is the school situated in 40/12?
No, it's a vacant land. It's a vacant land. Now the commissioner's report also discloses that they have encroached 40/1 also.
40/1 is separate. You have not come. You have not.
There is a person. There is a person who has no regard for law. If he has approached, like for example, if I have to go to the KT to say there is a violation in somebody's my neighbor's property, Now they say also file an affidavit saying you have not violated. Can somebody in unity encroach a government plan, which is admittedly given, which the commissioner's report itself says, and then come back to say that 40/12 belongs to after lapse of how many years? After lapse of how many years? Why this right was not exercised at the earliest point of time? So therefore, the keeping Janata's judgment has to be established by documentary evidence, not by oral. He cannot read any oral. I have filed my synopsis.
Yes, yes.
And the boundaries by way of a memo which is. And with regard to adverse position.
You cannot give up your claim now here. You cannot give up your claim here.
No, I cannot pass by.
No, correct. You cannot give up your claim in your written statement, whatever you have stated.
Law says, claim cannot have mutually respect.
Correct, correct. Please, in a written statement, you can take any number of
Any number.
But when you
cannot pass by admission.
Yes. Yes. That's all, Alva. Nale for dictation. Where is he?
They can take action in accordance with the land grabbing act is available.
Yes, sir. Which is that matter? Settlement, what happened? We listed after the Dasra vacation. You can take your chance after that. We have not heard this matter. Only for settlement, we said.
Yes.
Not agree. It's not possible. No. Which is that serial number? We have so much of further hearing. And if you take a fresh matter, the other further hearing would remain the. Which is that serial number? Is this matter in the week commencing from 21st October? Further hearing done. You file a synopsis, Mr. Both of you all file a synopsis. The file a synopsis. Both the, it would be easier if at all we reserve it also. If he has made a case for admission, we will frame a substantial question of law while arguing, when we are arguing the matter. Correct, let them argue. See, which is the suit, their suit came to be dismissed. Trial court. Before the first appellate court, it was modified. For item with me, now in their suit was entirely dismissed. Before the first appellate court, allowed in part. Insofar as non-granting of certain properties, it was still here, correct. Confusion bad. So to that extent, they have sorted out. Now we have to say whether the first appellate court was only justified in awarding decreeing the suit of the plaintiff in part. Ade barodu question of law, because we have to consider your appeal and their appeal as well. No, we cannot bifurcate that way. We have to say whether the first appellate court was justified in dismissing the suit of the plaintiff insofar as those properties are concerned, because he is aggrieved by that order. So we will answer that. See, now that it has been connected, when it was connected or when it was made to be connected, you should have raised that objection. No. If their appeal was their appeal nalli connect madidre, your appeal would not have come first. It is in your appeal you have connected this RSA. No. If that was so, their appeal would have been listed first and your appeal would have been next. Now in this appeal, ಯಾರು ಯಾವಾಗ ಹೇಳಿದ್ರ ನೋಡಿ ಯಾವ್ದ್ರಲ್ಲಿ ನೋಡಿ. Why don't you settle the matter? Yes, why don't you settle, Mr. Now, in certain properties you have not been given, right? Which are, how many properties are there? And who is he? He's a son. Anna. Genealogy ಕೊಡಿ ಒಂದು. ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಜಿನಾಲಜಿ ಹೇಳಿದ್ರಲ್ಲ ಒಂದ್ ಕಡೆ. Even Patel Singhe Gowda is alive. Lakshmanma is the first wife. Jai Kumari is the second wife. And Sushila is the plaintiff. First wife. You are not giving share to Sushila. ಫಸ್ಟ್ ವೈಫ್ ಮಕ್ಳಿಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ, ಸೆಕೆಂಡ್ ವೈಫ್ ಚೆನ್ನಾಗ್ ಅನ್ಸ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರ ಮಕ್ಳೇ ಅವ್ರ ಹೆಂಡತಿ ಅಷ್ಟೇ ಅಲ್ವಾ? ಅಲ್ಲೇ ಅದೇ ಈಗ ಫಸ್ಟ್ ವೈಫ್ ಮಕ್ಳಿಗೆ ಕೊಡಲ್ಲ, ಸೆಕೆಂಡ್ ವೈಫ್ ಮಕ್ಳಿಗೆ ಚೆನ್ನಾಗಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿರೋ. Your husband, that who is this Patel Shingegoda? He wants to be happy with the second wife now. Who? Second wife. First wife alive ಇದ್ದಾಳ ಅವಾಗ? First wife. She's alive. Then second wife's marriage, the second marriage is not legal. Allah, see, if you say plaintiff's mother is alive, and he has married second wife during the when the first wife was alive, then that becomes an illegal marriage, void marriage, and then the children born from that marriage would be illegitimate. Now, in the event this court holds that these are all the joint family properties, then the Sushila would get share in the property. So tell him to give some share to. What is your expectations? See, we are not on merits here. What is your expectation? Trial court dismiss your suit in entirety. That is what we are saying. No. Trial court dismissed your suit in entirety. Did not give any property, any share in any property. First appellate court ಏನು ಕೊಟ್ರು ನಿಮ್ಗೆ? Into 3529. Now you are against 4 and 4, 10, 11, 12. You are against before this court. 4, 10, 11, 4, 10 to 12 are the ancestral property or no. 4, 10 to 12 are agricultural lands or house properties. He says it is a self-acquired. be one property which would be her share of the property, entire. She would be entitled for how much? One? Half share. Half share to the plaintiff, how is that? Yes, half share. See, Mr. Mohan Kumar, see, in the event, this court holds that it is the joint family property, then the defendants 2 to 4 and defendant number 8 would be getting notional partition in the share of the father because they are the illegitimate children. So, initial partition has to be taken place between defendant number 1 and plaintiff. So, half. Once there is half, then defendant number 1's share, half nalle. Again, Sushila will get one share. That is 1, 2, 3, 4, 5, 6, 1/12 share. So, half plus 1/12 share she will get. So, what would be her total share in all these properties? If the court holds, that is what I'm saying. Then he is entitled for that other properties at least. Where properties ideyala? Really? You tell him, we are going to dismiss his suit. You tell him we are going to dismiss his appeal. This appeal second, your party is here right before the court. Tell him that we are going to dismiss or give some share to her. ಎಷ್ಟಂತ ಹೇಳ್ಬೇಕಲ್ಲ ಕೊಡ್ಲಿಕ್ಕೆ ಎಷ್ಟು ಅಂತ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟು 6.5 acres. ಇದರಲ್ಲಿ ಅರ್ಧ ಸಿಕ್ಕರೆ she'll get 3 acres. ಆಯ್ತು ಎಷ್ಟಿದೆ ಅಷ್ಟು ಬರೋದಲ್ವಾ? They will not be entitled for more than what is not there in the family. ಆಯ್ತು what is not there will not ask you to give. What is there ಕೊಡಿ. One and a half acres she'll be entitled little more than that, right? Give her some property more than that. One ಕಡೆ ಕೊಡಿ. ಆಯ್ತು you have to sit across. You have to sit across. No, she's your daughter. I agree. Understandable. She is a lady. She's not there. She's married. Then he married second wife when the first wife was alive. He married second wife. He's got sons from that second wife. Now he's happy with that second. Correct. You should give her a legitimate share, right? So what? Give them a better property. Allah, I three. When will you settle? What was your settlement? What was your settlement? You should know what is your settlement, right? ಈ ಶಿಂಗೇಗೌಡ ಅವ್ರೆ ನಿಮ್ ಮಗಳಿಗೆ ಏನು ಕೊಡೋದ್ ಬೇಡವಾ ನಿಮ್ಗೆ? ಸುಶೀಲಾಗೆ ಎಷ್ಟ್ ಕೊಡ್ತೀರಾ? 1 ಎಕರೆ ಜಮೀನ್ ಏನಾಗತ್ತೆ ಅವಳಿಗೆ ಹಿಸ್ಸ ಎಷ್ಟು ಬರ್ಬೇಕು? 3 ಎಕರೆ ಬರ್ಬೇಕು. ಅಂದ್ರೆ ಏನು ಮದ್ವೆ ಮಾಡ್ಕೊಂಡಿದ್ದು ಏನು ಉಪಕಾರ ಅಲ್ಲ ಅದು. ಸ್ವಂತ ಮಗಳು ತಾನೆ, ಇನ್ನೊಬ್ರು ಮಕ್ಳದ್ದು ಮದ್ವೆ ಮಾಡಿದಾರ. ಎಷ್ಟ್ ಕೊಡ್ತೀರಾ ಅಂತ ಕೇಳಿ ಅವ್ರಿಗೆ. Please ask your party to be present tomorrow. Let them be, let him also be present. Sit across and cross. Talk. Tomorrow, both the parties, both the council submits that they would make an endeavor to settle the matter. Not at 2:30 morning hours. Parties to be present tomorrow. Yes. Madam. See, they are ready. What is her age? He is only, what is his age? ಅಲ್ರಿ ತಾವ್ ಸ್ವಂತ ಮಗಳನ್ನೂ ನೋಡ್ಲಿಕ್ಕೆ ಹೋಗಲ್ಲ. How is he aware that what is she suffering from? ಅವ್ರ ಮಕ್ಳು ನೋಡ್ಲಿಕ್ಕೆ ಹೊರಗಿಂದ ನೋಡ್ತಾರೆ, ಚೆನ್ನಾಗಿದಾರ, ಒಳಗಿನ ಕ್ಯಾನ್ಸರ್ ಏನಿದೆ ಅಂತ ಗೊತ್ತಾ ಅವ್ರಿಗೆ? See, the sons will not be even bothered what she is been doing and all. And the father says she is very well. Can you be assuming when the father, when she itself says she is suffering from so and so disease? ಹೊರಗಿನ ಕಾಣಿಸ್ಲಿಕ್ಕೆ ಚೆನ್ನಾಗಿರ್ತಾರೆ, ಚೆನ್ನಾಗಿರೋದಂತೆ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ ಚೆನ್ನಾಗಿ ಇರ್ಬೇಕು. Ask him how much he is giving so that you can talk to him. You talk to him and say tomorrow. Naale barli for reporting settlement. What happened? Settlement? Huh? You said that you would explore. Right? Yes, senior counsel, what happened?
That's client was prepared to pay 5 lakhs as compensation. I don't know. He has put up a claim of 27 lakhs in his memo. Obviously, he is not interested in settlement. And so, since the matter is already argued, there's nothing more for me to say, my lord.
One packet of oil, right? Oil. Charges for regarding the theft of 1 liter of sachet.
The oil from the motorcycle. Evidence was there, and evidence was ignored by the labor court. That was brought to the notice of your lordships, and then your lordships told the other side that he should accept 5 lakhs or face a dismissal of the with the allowing of the writ petition.
5 lakhs are not agreeable, right?
Not agreeable.
It has to be, your claim has to be. They have caught you for the first time. This incident came to their knowledge at that time. We don't know what has happened. Alva, look at this incident. They have caught you for the first time. It is not your case that there is victimization on part of the management in framing a charges against you for this offense, for this misconduct rather.
How the oil sachet was carried from kitchen to the vehicle, there is no evidence. All along, everywhere there are CCTV cameras. They did not conveniently place any CCTV cameras regarding the.
Convenient ಏನು ನೀವು ಅಲ್ಲಿಂದ ಬರ್ತೀರಾ ಅಂತ ಗೊತ್ತಾ? That camera.
There's no CCTV.
It is not that during during the misconduct which has been alleged against you according to you, at that point of time, they removed that camera and did not witness this incident. Then
Which I have submitted to the agricultural tax. They have not placed any such cameras in spite of they being available for the management. Even the head of the kitchen, who is they have not stated anywhere there is
packet exhibit.
Exhibit proof will evidence, that's what labor
In
says.
his bike, it was there.
He agrees, it was in my bike.
head of the kitchen, that is L66. He had the dry and wet store. On the other hand, the respondent was
you know the inquiry proceedings cannot be as done in the criminal proceedings. Here, little evidence is sufficient. So preponderance of probability is very little.
Because the respondent was only South Indian in the entire kitchen.
This is South Indian, North Indian, and
because it was feeling to be only
as though you are not part of the country.
8 years he was working there. 8 years he was working.
We are in a country, we are all one only, whatever it is. North Indian, South Indian, anta illa illa. South Indian dishes are more good, right? Then where is the question? Is it your ground that this North Indian, according to you, they have victimized him and they have put a near to the management? How did you prove that then? Evidence is, what is the proof to that? What was the victimization? In the sense, what are the harassment they were caused? Did you make any mention to the management that this is what was going on in the establishment? Is it your ground that when you were working in the establishment, that there were so many incidents where this you were victimized, being a South Indian, you were victimized, and all had transpired, and have you given any complaint to the management regarding that aspect?
I have orally informed the management, but they have not taken any action.
Orally is different than taking a written complaint. Written complaint you can always give when you really want to give. Really want to give, you can do many means, Alva.
They are working together. Yes. He cannot take them by arm. The other the workmen or Malota, all majority of them work in North India. Except I am the only South Indian. I cannot
will not accept this. You are dividing India into two parts.
What happened about any incentives? The respondent government
will not accept.
The report has examined the entire aspects of life. Just come to the clear conclusion that the respondent government has not committed to this project because there is no positive evidence to establish that the oil jacket was carried from the kitchen to the vehicle. If it is not, he has been carrying the jacket now in his hands or not in his shirt. Then that's a different thing. Somebody has placed this material in his vehicle because there was a lot of civilian activities for there.
What would have arisen if at all you had some material to show that there was some victimization going on in your establishment and you had brought to the notice of this management?
In my affidavit. Before the note of the labor court as well as before the responsibility of petition management. That is I cannot place any material proof.
We have heard you, Alva. We have heard on this. We have heard.
For some time on the last occasion.
For dictation on Tuesday. ನೀವು ಮಾಡ್ಲಿಲ್ಲಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು? We given an opportunity.
I am reinstated, I will get 50,000 rupees per month. 5 lakhs per month even does
You
not
will
work.
get better. See, why do you want to work in an establishment who is making you? There is victimization. Don't work in such. You can work in better institutions.
So we have got another 4 years of service. Where can we get the employment by that day?
You must be working somewhere, right?
That has been distributed before the Tamil court. They have filed an application before the Tamil court. I filed the counter affidavit, produced the photograph. Everything is there on record to show that I am not working.
For dictation on Tuesday. Place. Kodi. You can place in this 2 days. Mr. Kara Samadhana. Extent of the Kara Samadhana, you can extend it to them. What was the total amount? Just tell the total amount.
Sure.
No, just tell the total amount. What was the claim made by you? 4 lakh? 4 crore?
406.
Interest. This is?
4,406. This is the rental that is due from him. In respect of notes, the three tenders in respect to 3 taluks, for which notes he was the highest bidder, and for which there was a lease agreement. He continued notes for some days.
3 months.
3 months. And thereafter, because he was not able to furnish the accept the deposits, because it was forfeited. How much he has paid? The sum of rupees.
2,90 lakhs, 49,000.
And BMD.
He has paid this amount.
He has paid this amount.
So what has been remaining?
He was supposed to pay the entire principal amount, which is 4 crores 71 lakhs, and the interest would be waived. EMD also, EMD 2 crores 52 lakhs. 2 crores 52 lakhs 45,906. EMD was already forfeited.
That is in respect of
Now, what he is saying is, according to our scheme, if there is loss, then I will adjust the EMD even for losses. But in this case, there is no loss. So, insofar as customer scheme is concerned, you pay the interest principal amount. I will pay the interest. Interest is more than as on 2017, it was 10 crores. Yes, today not it is 2017. Now it would be almost double that amount.
If we waive this 10 crores, as per the Kara Samadhana.
We paid 2 lakhs, 2 crores 52 lakhs. 2 crores 52 lakhs, 45,906. Is entitled for waiver in terms of Samadhana 4 and 5. But when we issued the endorsement to him, asking me to pay, the Samadhana 5 numbers what it was. It has now numbers.
He has paid this 2 crores 52 lakhs. 45. Yes, no.
What he's saying is, 252, there was an EMD of mine. So 450 is adjusted. That adjustment is not permissible according to us. That was because there were losses, apart from rents. Now, because he was a defaulter, I had to retender it.
So that is not a loss for you?
No, I retender. If there was a loss, that also I can recover further.
But you did not incur any loss in the rate.
If there was losses, then under the proviso of only for losses EMD can be adjusted. What he is saying is for principal also adjust EMD. Yes, then business I verified. Last time of clearing, they were making the submission that 3 months I did not do business. I verified they have done business, and towards for that he does not want to pay the rent. Rent is what he has.
So he has done business in that premises.
And it's not reminded to entire taluks, all the shops.
All the shops.
The three taluks, the entire
Wherever shops he has.
wherever entire thing is yes. For 3 taluks, so he had the 3 taluks for his business, and whatever he paid, that is what we are asking for. Now he has to do. Even now we are saying that interest should be there. Not for interest, saying he paid in 52.
Yes.
Then senior said that we will place some authorized.
Yes, what happened, Mr. Sir, senior counsel? See, ultimately,
Single case that from first July to 3rd June, the figures will be that exchange law.
yes.
The lease loan in which
either tender or auction will be called for. The month of April or May, whether the tender or the auction, the highest bidder will be given the lease.
Yes.
Before granting the lease, the security deposit of 1 month cash and 2 months bank guarantee. Totally, the 3 months security will have to be given in 60 days. In the meanwhile, the earnest money is given on the date of the auction or the date of the confirmation. Each day will be executed. In this case, there was a delay of 15 to 20 days in giving the bank guarantee. However, my lords, the business continued up to the month of June. For 1 month, they made a rearrangement, terminating my lease by giving, not holding a fresh auction, by giving to another person of the neighboring town, who also gave the equal amount or more. There is no loss. Now, my lords, I need permission to say, when the earnest money deposit will be forfeited, the earnest money deposit is forfeited in the event of the failure to furnish security. Not the petitioner to read the relevant rules. I will be permitted to read.
Which are you reading? Rules, sir? Rules, sir?
All deposits.
We're reading this conditions of license, right? Export.
The right of retail, not there in the problem. Collected body not there in the statement.
These and right of retail.
Yes. All deposits may not got 219.
Rule 18, alva?
18 other 19. Failure to execute will say 18 other.
Huh? Adjustment of deposit.
When a person in whose favor the disposal is confirmed, fails to comply with the provisions of Rule 16 and fails to furnish the security in the manner stipulated in the clause 3, 6, and 8 or Rule 1 of Rule 17, and within the time specified herein, the disposal of the rights of retail and of debtor shall be cancelled by the government and the deposit made by such person shall be forfeited to the state government. The right to retail and of debtor shall be disposed of fresh. It has not been done. They are allotted to continue up to the month of June. The 1 month rearrangement was in the month of June. Now I will make it Rule 19. All deposits unless forfeited in accordance with these rules shall be adjusted towards the final monthly rents payable by the person who buys it. Because we are dividing this scheme, these are all by this direct contractor. 3 months is given period for them to go for the next year with 3 months because it is there. For the last 3 months, it will be free of cost. When there is 3 months deposit with them, April, May, June month, they will have earning to go for things for the next year. That will be a saving in their pocket.
Yes.
So for that, this scheme is there. All deposits, unless forfeited in accordance with the rules adjusted, towards the final monthly rent payable by the person whom the license was issued. Means there is no recovery for the last 3 months.
Yes.
There is no liability of paying the day rental for the last 3 months because the advance money is there with them. So my submission is that, in this case, having permitted me to continue the business
30th of May, without disturbing the witness, there is no forfeiture. Forfeiture comes to place only when there is a default in furnishing the security. Security furnishing, there was a delay, it has been explained. 15 or 20 days delay was there. So my submission is that this amount of rupees 471 lakh 95,406, the security deposit given by me. Sorry, 2 crore 19 lakhs 49,500. EMD, earnest money.
Earnest money is 2 crore 52 lakhs 45,906.
Then the earlier rental. Earnest money.
Rental is 2.
28. Equal to 1 month rent. Number 28 is the notice. ನಿಮ್ಮ 3 ತಾಲೂಕುಗಳಿಂದ ಮುಖ್ಯವಾಗಿ ಹಾಕಿಕೊಂಡ EMD ಮೊತ್ತ ರೂಪಾಯಿ 2 crore 19 lakhs 49,500. This is the EMD amount. When they have forfeited, there is no forfeiture.
Yes.
Remaining amount of these 2 crore 52 lakhs 35,906 have been deposited. Yes. On the occasion, some petitions that and as per the direction we put, it has been paid. Throughout, I have been asking that my money is already there with you. You adjust it and absorb me from all liability because they, as a result of this, action under section 58 has been taken. PH is in charge over all my property. I am a penniless person now. Because all my properties are in the name of the Karnataka Sarkar. So for this, my lord, there were earlier occasions, this one the report, with one judgment is clear is of this. Identical cases there. One year development also has permission. You know, trouble your worship. Everything for this, not for designing, I will not trouble your worship. I will be saying the case of the first case is Ravi Kumar Shetty versus State of Finance. It is the bench of Honorable CA and Party. ILR 2001. Karnataka page 4189. This is the case of the identical nature. There is an outfit director that such a procedure is not allowed at all. So this is not earlier as a separate measure. Legal presentation. Yes. This is the ILR. Ravi Kumar Shetty, I can read para 1. It is common ground that in the re-auction, the state did not suffer any loss inasmuch as more amount has been realized. The said order in India forfeiting the deposit was challenged by applicant by saying number so and so. The government secretary having not has noted the contention that the government did not suffer any financial loss on account of the applicant's default. Observe as follows. If the facts and as stated by the petitioner in this petition are correct, and if the petitioner makes a litigation to the state government for refund of the said sum of rupees 1 crore 25 lakh and other appropriations, the state government should consider the application on its merit in accordance with law and pass order in its way. Identical case will also that Ravi Kumar Shetty was the contractor and on the contrary of the that statement, but then,
Yes.
Case has been also claimed in the case of Raghavendra, case of Karnataka, it's issued another versus the Raghavendra. It's also the honorable implement has dismissed the thinking of the state government. So with this, it is very clear that
ಕರ ಸಮಾಧಾನದಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
my suggestion is one of that. Otherwise, they have been, my case is they have passed an order to effect that. Unless my deposit has been registered.
Now, now only a notice has been issued to you, right?
No, they have taken action of recovery. Because of the earlier expedition and all, the recovery, the process of auctioning my property has not been done. Apart from this, Deputy Commissioner exercising the power, 58, has created a charge over my property. As a result, because the institution, they are not being sold, but my property is transferred. Page number 34.
Yes.
Yeah. Yes. This case, you are connected with other petitions. The will be on page number 34.
Yes, yes.
Yes. And the G.
Yeah.
There are 6. Page number 40. You are 40?
Yes, yes.
The David Prasad Shetty when the definition of the petition submitted that several properties are having number 88. The taxes equivalent case. And you know the fact that the petitioner from the 2028. Under the deposit is 2 lakhs 45 the year. With the respondent authority, and if the same is accepted by the respondent department in terms of Karasamadana scheme number 4.
Karasamadana is only for interest, alva, and for the loss.
It's not interest. My position is this amount has been deposited in terms of the other direction. Yes, my only the difference is now the investment deposit is available with them.
Correct. You want to see where have you deposited this 2 crore 19 lakhs 49,500?
It has been accepted. It has been admitted that.
They said that you have not deposited. They have not deposited. 252 is not. EMD. And they say 252 is the rental. They're saying as per that. That's why this board is unable to understand. See, come to that order which has been passed by you. 1 second. You read that impugned order, no? Where is that? Annexed? Adalva. Idu amount 2,19,000. Page 22. In that it is stated. ಇನ್ನೊಂದು order ಓದಿದ್ದೀರಲ್ಲ ನೀವು. Which is that notice? 28. You read the notice and said that 219 is the EMD. Yes. They say that is not forfeited.
Cannot be forfeited. You cannot have it.
The amount is already forfeited. Yes.
You forfeited. And it's just give a figure.
No, yes, because he said EMD is 219.
219
Ah.
That is the EMD.
252 is rental.
No, no. 250. Now what he is doing is 471 is the rental.
So he's dividing that into.
471 is the rental is supposed to be. Maybe the rental rents of 471 and maybe the customer. What he's saying is 219 EMD is there separately. I have paid 252, adjust to he has exactly paid 252 minus 219. And he says EMD also you please consider and give you waiver of interest. That is clear.
So the facts are, in fact, the rent due is 4 crores 71 lakhs 95,407. That is the rental due. According to the petitioner. According to the petitioner.
So see, because we had according to 219 is with us.
EMD, which is forfeited or rather not forfeited. EMD of 219.
This is 471 minus 219 is 252.
219.
He pays 252. It says please adjust it.
On 219 49 of 500 to be adjusted to the rentals.
The rentals and also waive the interest. Now the case of the state notes is simple.
And waive the interest.
The case of the state notes is simple. So far as EMD that is already forfeited can be adjusted only for losses. There is no loss here, so therefore proviso is not applicable.
252,906 is already paid. Already
so you pay 219, I will that is a complete endorsement. You pay 219, I will waive the interest. That was because customer scheme was there before. And last time it was argued because it was not allowed to extend in 31st of December. In fact, I said the court would pass an order. It is ready to pay 219. For that, they said it can be what he's saying is 219. Now, their argument is on that it is not forfeited or it is not liable for forfeiture. Where is the statement? Page 16. Right for me. Page 14 says it. I think
when was the forfeiture?
11/11/2003. It is not challenged. I filed statement of obligation, served the copy on them, and even if there is no collateral challenge, you cannot say it is not have to go.
Forfeiture.
So you are talking.
Yes, yes.
Right, obviously. Right. EMD is already forfeited on account of default in 2003. I was supposed to receive 471 in the rentals, which he does not pay till now. Statutory accrual of interest loss is at a particular rate. 9,000.
So according to you, if he pays 2 crores 19 lakhs 49,500.
Customer is still available. He will get the benefit endorsement. Page 22.
Page 22.
But that is the obligation, but detailed endorsement starts from page 78. The operating process is what I have said. I will say this to the 290 year to please adjust.
This is the order.
Order.
So the petitioner's contention is please adjust EMD Up to 1949,500, which according to him is not forfeited.
We have been saying that not now, we have been saying not to the earlier.
To be adjusted to rentals.
Because as a method of provision, adjustment of EMD is available only for losses. In this case, there is no loss, I cannot adjust. And waiver of interest is still there. You pay the principal amount is what we are saying, rentals. Last time we were getting lost to the statutory provisions.
No, rule 19, right? Rule 18. Regarding forfeiture. The deposit under rule sub-rule 1 shall be at the risk of the defaulter, who shall, however, be not entitled to any excess amount released from such disposal, but shall be liable for the losses sustained by the state government. The excise commissioner shall be entitled to assist, provided that in those cases where the applicants are applied for the current sum are asked, wherein the earnest EMD was forfeited, the same shall be adjusted towards the losses sustained by the government from redisposal of rent, right of retail rent of liquors and any amount in excess. No, if you have not sustained loss,
sustained loss, there will be an additional demand for losses also. So,
provision is something, the same shall be adjusted towards the loss. So if you have loss, you will adjust that. If there is no loss, you have to repay that amount, right? Then what do you do of that amount? If you
and the amount in excess shall not be refunded. So if there is a loss, I can adjust it. If there is no loss, even if there is a loss,
come again with that, come again.
Provided for those cases where applicants have applied only in September and where the additional deposit was forfeited, the same shall be adjusted for the losses sustained by the state government from redisposal, that is the auction of the rent of retail vehicles, and any amount in excess shall not be refunded. Any loss still persists shall be recovered as it is unless recovered
Of land revenue.
there is a land revenue already
First condition is loss. If there is a loss, please adjust that amount. Alva, if there is no loss, then if there is no loss to you, you have to give back that amount to them, right? Let us understand. In a general perspective, you give a tender, okay? You give a tender. The persons deposit some amount. The tenderer deposits some amount. For example, 100 rupees. According to the clause, you say in the event you don't complete the tender, the amount would be forfeited. With the clause that in the event I suffer more loss, I would recover from you. If I suffer more loss, I would recover it from you. In the event I don't suffer any loss, I give it back to you. That is how this is there. Profit or loss. So now there is loss and you are entitled because you have sustained loss because of the non-implementation of the on part of the person. Non-implementation has made you put you into loss. Now when you show that there is no loss, then what should happen to the forfeited amount?
Person to bid has to give an interview. Now, if you are not a successful bidder, there will be only one successful bidder.
Correct.
If you are not a successful bidder, the EMD will be returned and that is
correct. No?
That will be the contract. This contract, then the contract is given to you. Now, after I give you a contract, you don't perform that contract, or you don't adhere to the conditions of one of the.
Correct. You don't perform the contract. According to you, you forfeit that amount.
I am entitled to forfeit the GMT. And then not I am entitled to, let us assume, re-auction it or retender it or whatever we call it. Now, at the time of retender, if there is any loss sustained, I am entitled to recover that from him. Apart from the EMD scheme, EMD is already forfeited. That earnest money will not concept of earnest money in law. Like earnest money basically means that a person who comes fixed is to show his earnestness that I am serious about this. Earnest money is always entitled to forfeiture in law. I have forfeited the earnest money till I introduced proviso A. That was in 2000.
So you are in a double profit. Is it not? Let us understand. Maybe for the purpose of
There
the,
is no much of profit.
you already have got the EMD amount with you because of the non-compliance of certain terms of the conditions of.
Not entitled. If there is a loss,
Right, it is not. It is something that which is there with you now. That amount is there with you.
State. That amount was any note because the amount was there is a mistake from 2003. 2003 onwards he has not paid any amount. 252 megawatts amount that he pays was only last 2 years back in place. Interest has accrued statutory megawatts at a particular rate all these years. All that is not losses for him. Now I have ordered a scheme. The scheme is twofold. One is waiver of interest. Interest is in respect of excess areas. Excess areas means rentals is that is one portion.
Correct.
Second portion there are two aspects of it. One is excess areas where you have actually utilized it and therefore are liable to pay the statutory rent.
Correct. Is it your case that the forfeiture amount cannot be given back to you until there is a loss to be sustained? Hala. If you read this.
In that case, we can also kindly see second page. The earlier rule 18, as it existed, proviso also was not there at that point in time. Because EMD was always forfeited under section under 19. Forfeiture of EMD was. He's not challenging the forfeiture. And even in other cases, he is not challenging the forfeiture. He can say there was no loss sustained to the government. Challenge, you are asking for an adjustment. I am saying, but customer will do things to it. I just
Yes, just a moment. Act is made for litigation. This act is made for litigation. Earlier, we can imagine what type of this act would have been or the rules would have been. So much of that is not there.
For state election body is not there because of that litigation was more. Civil court jurisdiction is taken away. And I can because of that, government was not able to control this.
This is made for litigation.
One having working in French.
Without the court concerned with CL9 or CL7, we have to look into this now. This court is not even having any benefit of the CS7. Yes. No. Ah. It is only for waiver of interest. Correct. This appears to be little very not very correct. See, if you not forget about this rule.
No, I'm saying not what the code is.
Ah. No, look at this aspect how it is. They are unable to pay that deposit. First of all, they are unable to pay that deposit entire amount. They take some time. Okay. You forfeit that amount. That amount is there with you. There is no loss sustained to you.
That amount we are not taking. The amount is there.
Correct. There is no loss sustained by you. That is a benefit for you. Why don't you adjust with that amount? What happens for forfeiture? You take the retain that amount, right?
Forfeiture in law is forfeited in a contract. If there is a forfeiture clause, it is forfeited.
Forfeited in the sense he is not getting that benefit. You are getting the benefit of that forfeiture.
It's not a benefit. He should not have in the first place. He will not follow the contract.
That is the look. What I am trying to tell you is.
But the total context of the business that happens there.
It's like an agreement of sale when you enter into it. I mean, if you don't enter within a specified time, I will forfeit that amount and that you cannot claim as a. Yes, yes.
Forfeiture is statutory. I am entitled to forfeit. Now, I only introduced the scheme saying that, says arrears, so far as rentals is concerned, that is called the principal amount. Rents, he has to pay me the rents. If he has done business for 3 months, he has to pay me the rents.
Correct.
That amount.
He doesn't deny that he has to pay the rents. He doesn't deny it. What he's saying, please adjust.
What he's saying is,
No.
I want waiver of interest. I want adjustment of my waiver of interest. I am giving loss.
In the event he doesn't seek for that amount to be adjusted of the forfeiture amount, that you would be at benefit.
No, I don't think this is the. I mean,
but there's something is not very correct with this provision.
Yes, then he has to charge
forfeiture.
The forfeiture order of 2003, the forfeiture entitles me to forfeiture. I introduced the system because I was not, the state was not able to realize the same barriers. So, 1, 2, 3, 4, 5, finally we are in 5.
You made a benefit for somebody and then put into loss.
Because interest was piling up, I decided to give up interest because interest is something it is like building gases in there, it is going on and on. Instead of that, let me recover my principal amount. I said, okay, in this scheme, where the principal amount, I am now, so far as UP amount is concerned, UP has been forfeited.
No, that is understandable. You have forfeited, order is passed. He has not challenged. Well, he has not challenged that amount. Now, as per this, he says the forfeited amount can be adjusted by you, provided it is towards the loss.
No, like yes, now he says there is no loss.
Well, what happens to that amount? It is forfeited. That's all. That's all. And you cannot refund or adjust it or.
But the loss is 200 rupees. Loss is 200 rupees. I have forfeited 100 rupees. There is a loss of 200 rupees. Then the loss 100 rupees gets adjusted, and I am also entitled to recover
100.
Now the loss, suppose
when there is no loss, 100 to 100. Then
forfeiture is 100.
You can pay.
For refund of 50. That is what the statute also says. So therefore, if 100 is the loss, 50 is the loss, and 100 is forfeited. If he is not entitled for refund of 50, balance. He is not entitled. Same logic will apply to 1 rupee or 0.
Yes.
That is what I am saying. Statute, not I give. This is my statute. I give a benefit. Amount is forfeited. All I am saying is you pay 2.15 the amount and take the benefit of 50 rupees. Yes. That is what they say.
Guru? Which is that? This division bench schedule. 4-2. This is the single bench judgment.
So far as that case is concerned, this is people applying about the law. According to the state law, that case is complication. We have made a small note of the case. How it is not
Coding. This is just the attachment. You just attach the face.
See the. Then Office was saying, the order of confirmation in 99. Then what's the knowledge by higher order was the alternate. Notice was issued to publish bank guarantee, immediately he expired. Then was issued an announcement, asking them to what the bank is. The woman responded to the bank. Then perhaps the confirmation was revoked, EMD was forfeited, and we re-auctioned it. The auctioning was lost to the government. Then once we issued the endorsement and demand notice first to the law. At that stage, most matter had come up before the court, first on which they are placed, order of the case, petition. This petition is allowed in part, the demand notice is also the state of the creating liability and action. After this, the amount of the demand in excess of the amount is here, the cost by issue of the state can record the sum of the then Roma also filed a separate interview, challenging that order. Then once the extract the calculated interview, Roma the order passed the less related. How is political There was no fault of theirs. Only it was a special case. Roma's case is being relied upon by different vendors now, who are bidders. Roma's case was a special case that this one was not confirmed regard even to forfeiture of EMD. But only on the ground because your husband expired. You also said you want to only humanitarian consultation membership was different.
It doesn't indicate in the relevant portion of the order, right? In the gist. Correct. Yeah, can you please?
Very compassionate.
Yes, yes. We will take it on Tuesday for further any clarification.
Order. 77/2006. Because
That 11.
procedure can be done in the event of failure to furnish security in 60 days. Means 60 days from the commencement of the.
But that order is not challenged by you.
Without challenge, I check it taken out, no challenge, and I will put it to.
What happened to that
And
order?
then after challenge only the option. So one, the court suggested that in each case if you can bring any other person to run it.
You should place that order. They should have got to the notice. That should have been stated in the petition. That should have been stated.
And only there is there. And the schemes will be there, another 10 schemes will be there. Because the control and nitrogen will not leave them.
Yes.
They can go to areas.
Yes. Tuesday. It will be in the further hearing only for any clarification. This all matters adjournment. Other matters would be taken up. Yes, Mr. Bhargav. After vacation. 36. 36. ಯಾವ್ದು matter? Corporate line.
35.
33, my lords.
35. 33 is already adjourned.
After vacation,
Yes.
I thought
33 is adjourned, Mr. Kuttappa.
after vacation, my lord.
Vacation.
Aye.
Serial number 35. After vacation. In the week commencing from Murne Jisa. 28.
28. 36. This is Sitaram.
This is Sitaram. 36. Other after vacation. That's what it is.
37. Padmavathu.
That's what it is.
38. Ralapagowda.
It's a party, yeah? After Dasara vacation.
39. Commission required.
Pay for the petitioner, my lord.
Yes. No, we are not taking up this matter. We have not heard you, right? You can file it before the next roster bench.
Withdraw memo on non-appeal.
If we can understand. Now it's no, so that's why we listed it in the preliminary bid. We thought we would take it, but then you can file it in the counter. No, if correct, if we want, if this court is this court is supposed to hear this petition, then we will take your written submissions, right? But then when we are not.
I understand that, but a short date.
Yes, yes. In the week commencing from 14th, our date for it. 15th October.
Much obliged, man. Much obliged.
Shekhar. After then Lokesh. After Dasara vacation. Dasara vacation. Like week commencing from 28. Week commencing from 28. Mr. Bhatt. Shekhar.
5 India. 46 DR Mohan.
GR Mohan.
47 Abhinav Raman.
Yes, Mr. Raman. After Dasara vacation. Interim order granted earlier is extended to the next date of the Parasara Kumar. After vacation. Mr. Muniappa. Yes, respondent counsel, then counsel for the respondent number 3 seeks time to file statement of objection. At request 2 weeks time is granted. Not after tomorrow. First tell the other side. Yes, no. On first. The further hearing artist to be present, this one first.
Right. What ಆಟ ಆಯ್ತಲ್ವಾ ಅಷ್ಟೇನೆ ಆಟ ಆಗೋದು ಅಷ್ಟೇ ನೀವು ಕೇಳೋದು ನಾವು ಲಾಯರ್ ಇಲ್ವಾ ಹಂಗಾದ್ರೆ ಮನೇಲಿ ಇರ್ತಾರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕು ನೀವೆಲ್ಲ ಕೇಳ್ಬೇಕು